Yes.
May we make permitted to mention?
Appellate side?
Yes.
No, when you take up appellate side.
Very.
Yes. Right to the
Bolo.
Lordship, my senior is Dhruvo Ghosh. He is coming.
very well. We are hearing Mr. Gupta. Yes.
Please,
Please.
I
Yes.
was submitting on the other day. Those curious case of two wills,
Yes.
and the second one, which I am trying to probate, will get preceded, and the earlier will get revoked. Naturally, Honorable Justice Amitabh Lala's order.
Yes.
And then, Your Lordship, once I'm coming against the order impugned, which did not grant probate to my application. Bill. And I was on certain points. I will place certain judgments today, actually, because it so happened that I had two witnesses, which they filed their affidavits and they were cross-examined. However, in spite of such direct evidence, the court did not grant probate and relied upon certain handwriting expert opinion, which is the only, I think, main issue here, which I need to deal with. And on that, Your Lordship, first I'll just the probated will, Lordship, which has already been probated, of this is Saroj Kumar Chatterjee's will, Sabitri Chatterjee got probated the earlier will.
Yes.
Which naturally will get revoked. Now she had in that in this proceeding, after the affidavit, after filing the caveat, did not file the affidavit. And my respectful submission is that because of such situation, Your Lordship, it should have been, the matter should have ended there. The caveator who got title after that, I mean, the property vested, is Gopal Mitra. And Gopal Mitra, Your Lordship, got, as I had placed the will last time, a person to a very strangely mentioned in the will, a contract. I'd placed that part, which I will place also today, because it will be relevant. How a will has been executed.
As far as we have taken down, Mr. Gupta, you took through 3 points basically. One is that Sabitri has abandoned the caveat by not filing caveat.
Yes.
Secondly, she has an adverse interest because she sold the Raspberry property.
Yes.
Thirdly, that Sabitri's will, the other will is virtually a sale. It's for consideration.
Yes.
So these were the 3
Yes,
points.
absolutely.
Yes.
Much obliged.
Because we have taken down.
Yes, I was just recapping. It's
we have heard.
Always that's helpful, Your Lordship, when
Yes,
Your Lordship refreshes our memories rather than we refresh.
So the contours will be clear
Yes.
to everybody.
Now, Sabitri abandoning on that point, Your
Yes.
Lordship, I'll place Chapter 35, Rule 25. Should I hand over a book, Your Lordship? Or
Yes.
it's there?
No, chapter 35 is to here.
Original side.
Original side rules here, chapter 35. Chapter 35, which rule, Mr. Gupta?
25.
Original side rules, আমি জানি না এই কোর্টে আছে কি আগে তো ছিল। Please. What is share? Because we are not regularly taking up original side now, these rules একটু আনিয়ে রেখে দেবে না? Appellate side, original side.
Copy, Your Lordship, but
if you have an extra copy,
dilapidated condition, but
no difficulty, we can take that. But do you have a third
I won't
copy?
be able to read it, then I'll just
No, you just place from here, we'll share this.
Yes.
What did you just read it out from there, we'll share from.
Rule 25, Your Lordship,
Yes,
if I
we are
may read, affidavit in support of caveat. Where a caveat is entered after an application has been made for a grant of probate or letters of administration with or without the will annex, the affidavit or affidavits in support shall be filed within 8 days of the caveat being lodged, notwithstanding the long vacation. Such affidavit shall state the right and interest of the caveator and the grounds of objections to the application.
And 27 is also there.
And 27 is also there. Yes. 26, 27. It follows. Where 27, where the caveator fails to file any affidavit in support of his caveat in compliance with Rule 25 or in compliance with the notice issued under Rule 26, the caveat may be discharged by an order to be obtained on summons. So this is staring squarely on our face, Your Lordship.
But there's a may be discharged by an order to be obtained on summons. This was not done in your case.
Not done. That is when no
So then the
affidavit was
caveat
filed.
was not discharged.
Yes.
It may be that it is not discharged even if no affidavit is filed. 27 says where the caveator fails to file such affidavit,
Yes.
the caveat may be discharged by an order to be obtained on summons.
Yes.
So if that order is not passed on summons, then the caveat is not discharged.
Yes, but that should have followed. Till date, no caveat, no affidavit has been filed. So that is in violation of the rules. What I'm trying to submit, Your Lordship, is that
But if it is not discharged, then she retains her caveat. Because if
With-
this is the consequence,
yes,
they may argue that.
they may, but then wrongly. Wrongly it stands if a formal order has not been passed of discharge.
All right.
It is in violation of the orders. All I'm submitting, Your Lordship, that
Very
of the rules, sorry, Your Lordship, it is in violation of the rules. Now, when we see that it is in violation of the rules, if they, and they will, perhaps they did argue to that extent, not really pressing that point so much, that in that
But
case,
that's an irregularity, undoubtedly.
yes, yes. And it's not fair also, Your Lordship.
Yes.
These rules are to, and why this happened, bhuliye diyo.
But 28 also gives certain other consequences. The procedure that is dependent on the affidavit. Upon the
Yes,
affidavit
yes.
being filed, then the proceedings shall by order of judge
Yes,
such and such.
yes. I was coming
So we'll
to
also
that,
look-
Your Lordship, that it is in the nature of a written statement, so
Right.
that the entire.
So we'll have to see the cumulative effect of 27, 28, 25, 27, and 28.
Yes, just leaving it
Without a-
like that, or perhaps taking umbrage under that no order is passed, if that is argued.
Because unlike 148A caveat of the Civil Procedure Code,
Yes.
this here caveatable interest is disclosed by virtue of this that caveat. And there may be an adjudication on that also. So
Yes,
therefore, without an affidavit, that may not come fructify at all.
yes,
The caveatable interest may be in doubt also.
yes, yes.
This is unlike a caveat under 148 of Code of Civil
Yes.
Procedure. Here, the caveatable interest has to be disclosed by virtue of an affidavit. Very good.
And
We'll take that into consideration.
And if that is not done, Your Lordship, what it tantamounts to is that then it is followed more. If it starts being followed more in the breach than in the observance,
Right.
then that will be a dangerous scenario. And this has got a purpose. So that's what I was saying.
Yes,
And
that's-
now I will also point out, Your Lordship, why this was done. It may spring to mind, Your Lordship, that why they did not file the affidavit, for good reasons. Because then, Your Lordship, they had to disclose in these proceedings that
Will.
yes, that other one is pending, and we would have gone and contested. This is very important, Your Lordship. And conduct and suspiciousness in getting that will probated, the earlier one, which I don't think it's a will. I should call it a contract, if I may.
All right.
And with all this, if then it is relied upon, oh, there is no order passed, then that is absolutely not
Contrary to the rules and
reasonable. So the matter should have ended there. It follows from that.
She was the only the contesting party.
There were Roman and Topon, who were the nephews. They withdrew their caveat and objection.
So the effect of this Savitri's caveat failing would be there would be no contest then.
Yes. I was just coming to that, Your Lordship. It is I'm much obliged. Then it should have been like an undefended suit. And today with all their might, they are opposing. I will come to the sorry.
Who are opposing? Ramesh and the other.
No, not them.
Savitri herself.
Savitri and now Gopal Mitra.
Achha.
Gopal Mitra, the person who's enjoying the benefits of that contract through this will.
Achha.
Yes, Komal and Topon had filed the caveat. They withdrew their objection. And that is how it became a testamentary suit, because at that stage it contested because they had filed their objection. Once they withdrew, Savitri comes. And then she does not give this objection.
No, when Savitri came in before they withdrew, she had also lodged a caveat previous.
Yes.
She did not file an affidavit, and the other two withdrew.
Yes.
Great.
Now, Savitri thereafter executes this another will in a hurry, and it then gets probated, that will, which goes to Gopal Mitra. Now, the next aspect which I will come to,
Yes.
yes, now here again, Your Lordship, Gopal first
Yes.
filed a caveat which was defective, and then I will pass those orders as I go along. There was an order of Honorable Justice Oshim Banerjee that he may be allowed to file the caveat, and then that will be decided. Now, having filed the caveat and then the affidavit, he take the stand. He doesn't allow himself to be cross-examined. This is again a very important aspect of the matter.
He does not adduce evidence at all.
He does. He gives an affidavit, but that's about it. He doesn't take the stand. He doesn't allow himself to be cross-examined. Now, this is very serious.
He files an affidavit in support of the caveat,
yes, in support
or under Order 18 Rule 4.
in support of the caveat.
That is not evidence.
No, exactly, Your Lordship. And in that case, again, Your Lordship, this is the second tsunami which should have hit the proceedings. It should have ended. But today, lo and behold, they are appearing again, and with all their might, they are contesting. And they are saying, yes, we have a caveatable interest. On that, Your Lordship, I have prepared some of the judgments, Your Lordship. I'll come to, when I come to the caveatable interest, then I will file another compilation. Two compilations are here, which on the aspects of witness and handwriting expert. Judge, reference the These were cited, Your Lordship, before in the court below. And I would like to start off not with the judgment number 1, 2, 3, but I will first place 4, which is at page 28.
Yes.
this, Your Lordship, 5-judge bench of the Supreme Court, which is a much celebrated judgment, Your Lordship, and that time N.C. Chatterjee had appeared at the Supreme Court also, yes. And H.N. Shannal, Solicitor General, then much celebrated judgment, Your Lordship.
Yes, Shashi Kumar
It
Banerjee's
is-
mode of proof of will and all.
Yes. And it is good law, this, on the point, Your Lordship, that
Yes.
for the will to be probated, the main point which I am alluding to is two direct witnesses and evidence. Direct evidence will prevail over any expert evidence of handwriting, whatever that means. That question had fallen from Your Lordship, since they were urging on the last occasion that I have to meet that. Yes. And it is answered by the Supreme Court. Now, this is again a very important aspect of the order I am coming against. This was cited there and not at all mentioned or dealt with. So I don't know whether Your Lordship would be sent back for that to be considered or not. I mean,
Not
on others,
necessarily.
not
This is the law.
necessarily.
This is the law. This is not a
But-
fact.
But I do not know why this was not even, it's not even mentioned in the judgment. I would have alluded to how this judgment has been dealt with
But
if
there
it
is no
was
such-
dealt with.
right.
64. AIR 64, Supreme Court 520. So if I may come to Your Lordship first to page 29, head note B,
We are there.
evidence of handwriting expert, evidential value. The expert evidence as to handwriting is opinion evidence, and it can rarely, if ever, take the place of substantive evidence. Before detecting on such evidence, it is usual to see if it is corroborated either by clear direct evidence or by circumstantial evidence. Where the question is whether the will was executed on the date on which it purports to have been executed, and there are no suspicious circumstances attached to the will, the mere opinion of the handwriting expert that it was executed much later cannot override the positive evidence of the attesting witnesses, especially when he has not applied any chemical tests which, according to his own opinion, are essential. Now, here, Your Lordship, it's a simple case of a will which has been, two attesting witnesses have given evidence.
Both the attesting witnesses gave evidence.
One had filed affidavit who expired.
One would be sufficient under section 68.
Absolutely, Your Lordship.
Yes, yes.
That would, I was just going to say that.
One would be
And
sufficient.
the other one has given evidence, cross-examined and everything. So now, to take that point, that handwriting expert
Mhm.
saying certain things, whatever are on the merits, I will go into that. I will have to say something on that later on, what they had said, how they have said. That again is another matter, Your Lordship. In that case,
Yes.
handwriting expert evidence doesn't matter at all. I have got direct evidence. Page 31 of that judgment, Your Lordship. It's, if I may start reading from 7 lines from the top on the left column, Your Lordship.
Yes, please.
So the sentence beginning the entire will.
Interview.
The entire will is in the handwriting of the testator and has been corrected in various places, and the corrections have been initialed by the testator. It is not in dispute that the body of the will was written by the testator between January and March 1943, leaving some blanks here and there, particularly in relation to the numbers of immovable properties dispossessed of, and also in some cases the name of the particular legatee to whom the properties were to go. It also appears that the testator suffered from a severe illness in July 1943, and at one time his life was despaired of. It was after recovery from the serious illness that the will in dispute is alleged to have been signed by him on August 29. It is also not in dispute that the signature at the bottom of the will is signature of the testator. Further thought, at time there was dispute whether the date under the signature was written by the testator. The respondents have failed to prove that the date such and such is not in the handwriting of the testator. Now, Your Lordship, the disposition in the will are in favor of the various sons and grandsons of the testator and also of the wife. And wherever the testator had deprived any of the descendants of benefit under the will, he has given reasons for the same. Further, the will recites at the end that the testator had signed it in the presence of attesting witnesses, and that the attesting witnesses has seen the testator signing it, and that the attesting witnesses had attested it in the presence of the testator and of each other. In my case, here, Your Lordship, exactly the same.
63 language.
Yes, and he has, no, in the will, he has distributed to people of his own family. Various
So not so
relations.
suspicious.
Nothing suspicious. Nothing, and a philanthropic organization, Your Lordship, Bharat Semestrum Show.
Yes.
The main building, which is in a very prime location in Goriahat. But as opposed to the other suspiciousness in the other way, where Gopal Mitra comes from nowhere, Savitri comes from nowhere, and Gopal Mitra and Savitri records that I have entered into a contract to honor that I am making this
But
will.
that you have also challenged that will.
No.
That will has never been challenged.
No.
That goes automatically if you win.
After this case.
Yes.
So, and I will place judgment.
So because we cannot go, then we cannot go so much into the suspiciousness of that other will. Because if that is not challenged,
yes,
you have to restrict ourselves to your will.
Lordship, but
Prejudicial value, yes.
yes, yes. And since the caveat, yes, in order to
Yes.
prejudicial, yes, to some
To
extent.
prejudice us in that sense. But we won't be prejudiced because even if that will is bad, you have to win on your own.
And to appeal to the conscience of the court.
But we have to restrict our conscience to
Yes.
this will now.
And prejudicial is another word, maybe, Your Lordship, for conscience.
Because
But
that will the court's conscience will have to be restricted to this will. Your
yes,
will.
but since
Because there's no challenge to that.
and since the caveators are appearing here, Gopal Mitra, so that can be alluded to.
But Mr. Gupta, that's an unchallenged, that there is no challenge to that probate.
Yes.
So those probates stand as they are. You only have to prove on your own case.
ওই সাকসেস অফ গোপাল ওপর থেকে ব্লেস করছে তো page 36 next, Your Lord.
Yes.
Thirty-six of the compilation.
Yes, yes.
Page paragraph 23 also. Finally, we may point out that the expert admitted in this evidence that it was only by a chemical test that it could be definitely stated whether a particular writing was of a stated, whether a particular writing was of a particular year or period. It was admitted that he applied no chemical tests in this case. So his opinion cannot on his own showing have that value which it might have had if he had applied chemical tests. Here no chemical tests, etc. were done, obviously. Besides, he may add that Osborne on question documents at page 464 says, even with respect to chemical tests, that chemical tests to determine age also as a rule are a mere excuse to make a guess that furnish no reliable data upon which a definite opinion can be based. So even if that is done, that's merely a guess of the expert, cannot override the positive evidence of the attesting witnesses in case like where there are no suspicious circumstances. This is just one liner on this entire matter. I will now quickly go to how this has been dealt with. This has not been dealt with judgment, but how the handwriting expert and witnesses has been dealt with in the impugned judgment. Impugned judgment is at volume 3. It starts at 265. এইটা বলে পড়ে। Page 292, if I may take your look.
Yes.
Page for para 41, volume 3, page.
Yes, please.
Under section 45 of the Indian Evidence Act, handwriting expert evidence is admissible in court. The opinion of a handwriting expert, if proved by him in court, becomes admissible as evidence. Nonetheless, it still remains an opinion of the handwriting expert and is not binding on the court. In other words, the court is not bound to accept such opinion as sacrosanct and is not obliged to base its decision solely on such opinion. The court is entitled to come to its own conclusion on an issue like whether or not two signatures on two different documents are of the same person. However, since a handwriting expert is especially trained and skilled in the matter of ascertaining as to whether or not two signatures on two separate documents are of same person, the court would ordinarily give due weightage to his opinion. In my case, this is, Your Lordship, direct evidence was there of the
Section 72 probably is there also, Evidence Act 72 or 3, I forget, that the court itself can form an opinion. I'll just check up. No, not 73. Yes, 73 court may itself also compare section 73 of the Evidence Act.
But if direct evidence is there, Your Lordship, that will prevail, which the
Right.
five-judge bench has.
The expert evidence is not sacrosanct in that sense also.
In that sense, yes.
It's diluted by section 70. 45 read with 73 gives the court also a power.
So that's the
And
second.
you have a higher case that it
Yes.
should not have been looked into even.
Lordship, yes.
Well,
So that's the second dilution, and mine is no into no dilution, straight into the
yes.
direct witnesses.
Right.
Paragraph 42. It is the unequivocal view of both the handwriting experts who have been examined in this case, one at the instance of the plaintiff and other at the instance of the defendant, that the signature of the testator on the second will is not of the same person who signed the first will as testator. In other words, both the signatures are not of Swaraj by reason of this court having put its seal of approval on the first will by admitting it to probate. Swaraj's signature as testator on the first will must be accepted to be genuine or authentic signature. Now, Your Lordship, here I will try to bring in, I will finish that part, the last line. A very dangerous logic loop which is coming into this, which perhaps it would have fallen from Your Lordship, that today there is no admitted signature. What is being done here is the signature of the first will, which has been probated, is taken as sacrosanct. In that case, Your Lordship, necessarily follows that the second will never be probated, because the comparison is with the first signature. I mean, the signature in the first will.
But the first will has already been probated. There is no challenge to that probate. Why can't the court look into that? You cannot challenge that. That's a different proposition. But why should the converse be also true? Because the first will is probated. That has that now stands. I mean, no challenge to that probate.
Yes, but
But that does not necessarily mean that the signature can be looked into. Was the signature on the first will proved formally in this case?
We wouldn't be able to comment because we were not there. As I had indicated, Your Lordship, the first will was probated when behind the fact.
In your case, in
Yes.
this particular case, was the signature of the testator on the first will proved as evidence in this
No,
testimony?
no.
It was not.
No.
It was just looked into by the court.
Yes. And as that's what I was alluding to, Your Lordship, that there should have been an admitted signature, like in the bank. If there was a bank operation of a bank account, that should have been the signature to which it is compared. That's why I'm calling it a logic loop, Your Lordship. If I compare to one, which is the will number one, then I will never have a chance in the second will. And necessarily it will then mean, in that case, one of the will is forged. It will necessarily imply. Which may not be the case, Your Lordship. Which may not be, just loud thinking, Your Lordship, that which may not be the case. The first may be on its own right was signed 3 days earlier, and another one 3 days later. Both could have been signed. But what is being done here is the comparison of the first will is taken as sacrosanct, the signature, which is wrong. My submission is which is wrong. And in any event, all this doesn't matter because the direct witnesses, clerk of Anil Mitra had drafted it, and all these credible witnesses had said that yes, it was signed in each other's presence, and etc. All that, whatever is required to be done was done.
Yes.
Now, if I come to the first judgment, Your Lordship, for the moment, I might have to come back to this one for other
Yes.
points, but AIR 1971, Allahabad 29. Allahabad 29. This is on the point, Your Lordship, that Gopal Mitra did not take the stand and was not cross-examined. And he chose to do so. Because whatever objections he might have, then he has to state that before this forum, which he did not. Because the risk of cross-examination would expose a lot of things. Page 2, paragraph B, head note B. Evidence Act,
Yes.
section 17 and 114, admission or conduct of party. Party living and capable of giving evidence must come forward to explain it. Failure to explain, adverse inference. The explanation of any admission or conduct on the part of a party must, if the party is alive and capable of giving evidence, come from him. And the court would not imagine an explanation which a party himself has not chosen to give. If such a party abstains from entering the witness box, it must give rise to an inference adverse against him. So Sabitri doesn't file affidavit.
Yes.
And then whatever the value, I mean, prejudicial or not, that's another matter, Your Lordship. But it also has a legal consequence. Rule 25 I had placed.
Rule 25, yes.
Yeah. And here again, he was supposed to, this is the legal fallout. He does not take the stand. He doesn't allow himself to be cross-examined. And necessary adverse inference would be everything is very suspicious.
Yes.
In that case. The same judgment, I'll just place one short other bit. Page 7, running the compilation, page 7. Paragraph 17. About 20 lines from the bottom, or right-hand column.
Yes. Actually, we have marked the relevant portion. It starts with, we have, besides that.
Besides, huh?
Besides
Oh,
that,
yes, so one
till,
small marking might be there. Yes.
no, I have, we have marked right now.
Oh, Lordship.
So besides to conceivable, probably.
Besides, yes. I'll just read that. Besides that, he is the most competent person to state how he has been living and conducting himself since he attained since he attained the age of discretion and how others have been treating him. But he has abstained from entering into the witness box, and that must give rise to an inference adverse to him. The explanation of any admission or conduct on the part of a party must, if the party is alive and capable of giving evidence, come from him, and the court would not imagine an explanation which a party himself has not chosen to give.
Yes. Yes, Mr. Gupta, let us
Yes.
proceed because we have time constraints also.
Yes, I will just, I will place.
Please try to proceed a bit faster. I mean,
Paragraph, this other judgment, Your Lordship, next one, number 2,
yes,
1999, volume 3, Supreme Court cases 573.
right.
Vidyadhar. Yes, this, Your Lordship, running page, completion page 18.
Yes, 18. On the same principle.
Yes.
100%.
Presumption, if a party abstains from entering the witness was, an adverse inference would arise against him.
Here also
This is
para
Supreme
17.
Court. Yes.
Para 17 here also. Yes.
And page 22 also, paragraph 16 is important.
All right.
17, may I read, Your Lordship, just short.
Yes.
They were a party to the suit, does not appear in the witness box and states his own case on oath and does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct, as has been held in series of decisions passed by various high courts. Then the list of such cases, and the Allahabad High Court, then at the bottom, Your Lordship, is Arjun Singh versus Virendra Nath, held that if a party abstains from entering the witness box, it would give rise to an adverse inference against him. Similarly, a division bench of Punjab Haryana High Court drew a presumption under section 114 against a party who did not enter the witness.
Yes.
box.
Same.
Now, the next one, Your Lordship, is 1927 AIR Privy Council 230. Is that 23?
Yes.
See, on same point, it's the head note.
Yes. Yes.
Practice witness, and then reference, where it comes to reference, middle part.
Definitely.
The true object to be achieved, court of justice can only be furthered with propriety by the testimony of the party who, personally knowing the whole circumstances of the case, can dispel the suspicious attaching to it. The story can then be subjected in all its particulars to cross-examine. This opportunity was not given, taken, anything.
Absolutely. Yes.
And number 5, Your Lordship, last.
Yeah.
That's at page 38, and the relevant part, Your Lordship, is at the end. Page 40.
40 years. Why is this relevant?
Yes,
Mr.
this
Gupta?
is, Your Lordship, on the, I would cite this later, Your Lordship, when I'm on the handwriting, I'm analyzing the handwriting expert's report. Because the natural shakiness and the natural aberrations which should be there in a in such a case where the
This probably is a judgment of the precedent on the proposition that when the demeanor of and manner of behavior of the witness is not in consideration. If demeanor is in consideration, then trial judge is the judge who has the domain over that. Appellate court does not. But if demeanor is not concerned, then credibility of witness can be seen by the appellate court also. This is for that proposition.
Yes,
That
and
is
more,
besides the point in your case.
no, more so on the handwriting, because handwriting experts had given certain opinion. I will place it, Your Lordship,
Correct.
when that point I'm urging.
This proposition is that appeal court can also decide the credibility if the demeanor of the witness is not in question. If demeanor is in question, then trial judge prevails.
No, like Your Lordship, on page 40, the signature aspect is also considered.
There are certain
Yes,
others.
yes, there
Great.
is
We'll
some
look
other
at it.
aspects.
All right. You can place the judgment, and when we look into it, we'll,
Yes, Your Lordship, then
because we are on the judgment, so you can place it right now, the relevant portion, and then we can look into the impugned judgment in your case.
page 40,
40, yes.
on the right hand column, 2 lines from the top, if I may
Yes.
start reading.
Indeed.
Their lordships do not think that that is an objection in which there is much weight. Indeed, so far it seems almost in favor of the will being genuine, because if a man sets himself to commit a forgery, he would naturally try to make the signature as exactly like the genuine signature.
The signature was shaky, probably shaky. Shakiness of the signature.
The parts of the report I will show your lordship, which I had mentioned in the passing earlier. Two signatures are absolutely, if I may call, in a cyclostyle or digital copies. So no two signatures can be the same.
No.
However, that is what is being taken as the correct signature, because it's an exact. There were about 8 places where the signature was done in the earlier way, and exactly the same.
Hmm.
So that because there is no shakiness and there are no aberrations, that is the correct one. But it should be the other way around. There should be
In your will, there is some shakiness.
yes,
Achha.
natural shakiness. Yes,
All
and
right.
that is what forensic science says. And we all know, your lordship, that once and when one is signing, even with the most steady hands, two signatures are never the same. That is human.
Yes, yes, absolutely.
Yes. So, and one who wants to forge will make it exactly the same, trying to be overzealous to show the
Yes.
signature is
Too
right.
perfect.
Too perfect. Too perfection is not perfect.
No.
Too much perfection.
Neither in evidence nor in signature.
Yes.
That's settled by judicial decisions also.
So, lordship, there are this was the aspect on the witnesses, your lordship. So, if I may come back on the, I'll finish the caveatable aspect and one or two other points.
So let us do it, Mr. Gupta, because we cannot postpone it every day. Let us finish the argument, your argument, and then we can go on to that.
The caveatable.
The entire argument, your argument, please complete today.
Those judgments I will have to place, your lordship.
Make your arguments, only the judgment will be left, because otherwise it will be difficult for us to retain continuity. Because we have already.
Part, your lordship, which would remain.
Mr. Gupta, we won't grant any further time for that. You have to complete your arguments now. Because we cannot postpone it piecemeal, we cannot hear it piecemeal every day. And we cannot afford that luxury because of the pressure of the other bench. So
only difficulty is, lordship, those judgments.
If you have the citations, we'll take note and we'll look into those judgments and give the paragraphs also. There is a huge pressure of first appeals in the other bench. That's we are being very candid to you.
No,
we have to conclude these judgments. These are short matters.
Yes, it should be.
4-point matter. 2 points you have already covered, and just cite your judgments in that. And
lordship,
get it over with.
Judgments are not ready. That is the thing. Just I will maybe take 15 minutes
on the next day.
On the next day, that is. Whenever your lordship.
Only one more thing. If my learned friend favors us with a compilation, because he's saying page 40, but I think it's of the compilation.
Yes, yes.
But the note I will not be able
yes, yes. Please.
Your lordship.
Or your lordship copy, because I'll get it photocopy. He's marked everything in green highlight. It will come, all the important parts we won't be able to read. Before photocopy, it becomes black.
All these judgments were your lordship.
No, give a compilation, Mr. Gotta give a compilation.
It's in the from my chamber also, but I'm saying if the the compilation, the page
Yes.
numbers are being referred to.
The other judgments of their own, which they will cite, are not yet ready. And you asking for a photocopy?
No, at least the ones that they have done.
Their other judgments are not even ready.
If we do it.
But Mr. Gupta will give you 15 minutes on the next day to complete your arguments.
That is a promise, Your Lordship.
Thank you.
Then my
We
the
accept.
cases should be given to me so I can
Please,
start.
please, yes. In advance, please give the cases so that we can conclude on the next day.
Yes, yes.
Just give the citations to them, and if you can give a copy of the compilation also.
Lordship.
And definitely, Mr.
These
Ghosh,
citations I've got.
if those are very costly, then Mr. Ghosh will pay.
So I'll take a picture of your index. Then I'll know which judgment.
Yes, that would suffice. That would suffice.
Yeah, that would be okay.
If not his index,
This,
then at least the judgment's index.
Your Lordship,
One
this,
more
this
thing,
can
Lord.
be coordinated with the juniors, Your Lordship, not an
Lord,
This is not, you don't have to do it. So, Gora will
I
do it
want
with
to
you.
take a picture of his notes. He won't give me. Anyway.
that is
No, I was joking. My lord, as far as the records, your lordship has said the records will come. And if
Have-
we can take,
Have come, yes.
because the,
You can have a
my
look.
lord, we are saying that their witness, the plaintiff's witness, the
Mr. Ghosh, you
cross-examination.
need not give a reason. You are counsel, you can go through the records.
Yes,
Both of you
but
can go through the records if you like.
my learned friend can also check it, but from our document, the cross-examination has not been included of the plaintiff's witness.
In the paper book, it's not there.
That's what I'll check it, but if it's there, then I can.
Please do check.
what
That will
we
be
can
important.
check out what is not. It is there.
Question 39 of the Khali Chief.
Until 24.
I've cross-examined him. I've proved the will through him, his witness.
Mr. Ghosh,
I'll bring my
if you
copy.
have a copy, then
I'll-
give an advance copy of that also to them, so that they can also address that.
No, it's their witnesses cross-examination. I think it's an inadvertent slip. I'll check because my advocate on record had passed away also.
If you are going to rely on something which is not in the
No, I'll
paper book,
check.
Mr. Ghosh, give a copy to them.
Yes, I was going to check if it's in the record.
Do that. Absolutely. Please do that.
Your lordship keeps it next Wednesday. In between we'll come back.
Right. Very well. Third in part for further hearing on January 29, 2025. Thanks. Okay, our
These are my appeals, my lord.
Yes.
My lord,
You have this.
appearing for respond number 2 and 3, my lord. My lord,
One has been served. Their
Yes,
appeal.
yes, my lord, on the previous occasion, my lord had directed,
Can you please take the microphone a bit closer to you? Yes.
I apologize.
What had you directed?
my lord, on the previous occasion, my lord had directed us to approach the trial court, my lord, and since the injunction application was yet to be disposed of, to
This is
appear-
against an ad interim order.
Actually, there are two appeals, my lord. First appeal was against direction for exchange of affidavits. Now affidavits have already been exchanged. The pleadings are complete, my lord. So, my lord, from the next order, my lord, the interim order was again refused, my lord. From that,
my lord,
the
Is-
second appeal has been preferred, my
the
lord.
first appeal arises out of the refusal to pass ad interim order, and the second appeal, my lord, arises out of a direction for affidavits in the on the first instance of this, my lord.
Interim order obviously stands refused.
Yes, my lord. My lord, in
So it was taken up in the meantime in the
my
by the
lord,
land-
Mentioned on the last occasion. my lord.
yes, my lord. It
And
was
it's been
mentioned,
fixed
my
for the
lord, it has
29th.
been fixed on the 29th of this month.
So then we take it the Wednesday after that. Since the main matter, since the injunction application has been fixed by the learned single judge on January 29, 2025, comma, to await the outcome of the same, comma, let the present matter be posted in the list on February 5, 2025.
Lord, can it be in the month of March? I'll indicate why. I have an order 7 rule 11 against his main suit. That has to be taken up first. That will be decided. Then the main interlocutor matter.
Not necessarily, Mr. Ghosh.
Very
Let's
well, I'll
keep it
leave
on
to your
February
lordship.
5th. They have a right to argue on that also, that whether this can be till then, whether this can
Yes, yes, Lord.
You are right, because 7-Eleven hits the root.
Yes.
But even then, we'll consider whether
Not
even during pendency of 7-Eleven, we should protect them.
Well, I'll leave it to you.
Let it be on 5th. You can make that argument on the next date.
Very well. I'll come. Grateful.
Appellate side. Appellate side number continue করবো। সময় নষ্ট করে লাভ নেই। FAT 269 of 2022 is allowed on contest without any order as to costs, thereby setting aside the judgment and decree dated August 31, 2022, passed by the Learned Civil Judge Senior Division at Bardwan, whereby the eviction suit of the appellant plaintiff was dismissed. Accordingly, title suit number 41 of 2014 is decreed on contest, thereby granting a decree of eviction to the appellant plaintiff against the defendant's respondents. However, the suit is remanded to the trial court for the limited extent of consideration of the damages, if any, payable by the defendant's respondents to the plaintiff appellant. For such purpose, the said portion of the reliefs claimed in the suit is segregated from the relief of eviction. It is expected that the learned trial judge shall decide such issue and conclude the hearing of such part of the plaintiff's claim upon permitting the parties to lead evidence and giving opportunity of hearing to both sides on such limited issue as expeditiously as possible, preferably within 6 months from the date of communication of the judgment and decree to the trial court. Insofar as the component of the eviction decree granted above is concerned, the defendant's respondents are granted 90 days time from date to quit and vacate the premises and to hand over vacant, unencumbered and peaceful possession of the same to the plaintiff appellant and or his authorized representative. In default, the plaintiff appellant will be at liberty to levy execution of the eviction decree with immediate effect thereafter. If so levied, such execution case shall be proceeded with independent of the adjudication of damages by the trial court. We grant an eviction decree, within 90 days they have to vacate, they get 90 days to prefer an appeal or whatever. If they don't, you can levy execution in respect of the eviction part of it. And damages, trial court, it goes back to the trial court to decide whether you are entitled, if entitled, how much. That will be done within 6 months. Thank you. Today you don't have to give names. Names are already there in there. You can't add names there.
Item number 2, I do appear for the appellant, my lord.
Yes.
My lord, this matter, my lord, the appellant does not want to proceed with this application, my lord.
You have your written instructions.
I have my written instruction, my lord.
Learned
Well,
counsel.
May I
Yes.
submit one submission, my lord?
Yes.
My lord, one of the appellant died prior to filing of this appeal. That was an inadvertent error. I am seeking leave to file afresh.
You don't want to proceed, you say in one breath, and you're trying to file afresh.
I want to file afresh because the one of the appellant died prior to filing.
For
of
that
this.
purpose, you're withdrawing.
Yes, my lord.
No, you can file an application for leave to file against that person. Why withdraw the appeal and file afresh?
That
If you
was-
withdraw and file afresh, the limitation will apply then.
Then give me the liberty to withdraw it.
Take proper instructions, sir. If one of the appellants have not been, we don't understand. Please repeat.
One of the appellant has
Died. One of which appellant died? Died before filing the appeal.
Before filing of the appeal. That was an inadvertent
How
error.
could you file the appeal?
The power of attorney was granted prior to his death. The power of attorney holder has
Then-
filed it.
You take appropriate advice. You have to take appropriate steps. You can do many things. There are many options. Why withdraw the appeal? We can't permit you to withdraw the appeal to cure an incurable defect. So which appellant died?
My lord, appellant number 5. My lord, then my lord kindly fix this.
Purnima Naya. Her heirs are already on record.
No.
If her heirs are already already on record, we need not advise you, but you can make various prayers. If her heirs are now with you, they want to prefer the appeal also.
No, my lord, I have to take instruction
They
regarding.
don't. Then you have to file an application for substitution of those heirs as respondents and seek a transposition of this person.
Then my lord, kindly fix this matter on Monday. I will take proper instruction.
No, we'll record that you are seeking to withdraw the appeal on the ground and file afresh on the ground that one of the appellants
Has died
had died before filing of the appeal.
before filing of the appeal.
We will grant you liberty to file appropriate application. When you file the application, mention the application.
Then my lord, I'm waiting.
Learned counsel for the appellants submits that one of the appellants, namely appellant number 5, Srimati Purnima Naiya, Naiya.
Appellant number 5 or 6 that I have to take instruction. That is not clear.
Learned counsel for the appellant seeks to withdraw the appeal with leave to file afresh on the ground that one of the appellants died before filing of the appeal. Full stop, next para. However, such leave cannot be granted on the said ground. Full stop. Be that as it may, the appellants are granted liberty to prefer appropriate application in that regard. Full stop. But this much. No further order need be passed at this stage. হ্যাঁ সবাই তো করতে হবে ওই সাবস্টিটিউশন অ্যালাউ করে তারপর সেকশন 15
Wait.
অ্যাপ্লিকেশন ফাইল করতে আর ইজ নাম রেডি অর্ডার 22
Lordship, this matter has come up at my instance. My
অর্ডার 22 তো হবে না পেন্ডিং অফ দিস অ্যাপিল আগে মারা গেছে লিভ টু প্রেফার অ্যাপিল সরি ইয়েস
lord, this matter has come up at my instance.
ইয়েস
On the last occasion, my lord, there was not only on the last occasion, there were previous other directions, my lord, for transmission of the LCR, my lord. Till date, this is a
we sought a report
lordship. We have sought a report. There is a recording of the report, my lord.
দৃষ্টি যাচ্ছে ডাইরেক্ট ফিউচারে রিপোর্ট দিতে
And these are the two orders which was passed, my lord, initially, and thereafter, my lord. And thereafter, on 4th of October, 2024, there was another order that was passed by the division bench.
this is one order
This is one order. Thereafter, my lord,
4th of October
4th of October, my lord. All the requisites have been filed, my lord, way back in 2019, my lord, pursuant to the order of 2019.
you are appealing for the appellant
Appel- for the applicant.
learned counsel for the appellant points out that by an order dated December 20, 2019, appropriate directions were passed for the trial court records to be brought to this court, full stop, despite compliances by the appellant, comma, such records did not arrive, comma, prompting a different coordinate bench to pass another order on October 4, 2024, directing the department to take steps immediately for ensuring the transmission of the trial court records from the court concerned to this court. Full stop, next para. However, comma, we find from a report of the Assistant Registrar, Roman 2, comma, First Appeal Section, dated January 14, 2025, that in spite of repeated efforts and reminders to the concerned court, that is the Second Court of Civil Judge within bracket Senior Division, comma, Howrah, comma, the trial court records of title suit number 165 of 2013 have not yet arrived, comma, nor was any communication made from the end of the trial court. Full stop. Accordingly, we find no conceivable reason for such lackadaisical attitude on the part of the concerned department of the trial court in not sending the records till date, despite repeated orders of this court and reminders from this court. Full stop, next para. Accordingly, we direct the learned district judge, comma, Howrah, to send a report as to the reason for the delay and to ensure that the records are sent immediately to this court. Full stop. Such report shall be sent to the learned registrar general of this court, upon which the learned registrar general shall place the same along with the main file. Full stop. The learned district judge Howrah shall also ensure that the records are sent to this court at the earliest. Full stop, next para. The matter shall be, such report shall be filed by the learned district judge within 4 weeks from date. Stop. The matter be placed in the list on February 27, 2025, under the same heading.
Lordship. Lordship, only thing, my lord, there was a direction for filing affidavit of service, my lord, because we were directed since the respondent made
Affidavit of service of what? Service of?
affidavit of service, my lord, of
What were you supposed to serve?
because the respondent number 1 was not appearing right from the beginning, my lord. So there was
So we are
a
not taking those affidavits today. Today we are only on this. You're ready with those affidavits? Substituted service has been effected.
lordship.
You can file then. We'll record that also.
Lordship.
You have checked up. Oh, this is the only the publication.
What is the publication? Because the respondent number 1 was not appearing right from the
This is on respondent number 1 only.
one.
The affidavit, character line article, para article, the why application for appropriate order?
My lord, that was before the another
no.
coordinate bench, my lord.
Oh, this is the affidavit, sorry. Character line article, the affidavits of service filed by the appellant today be kept on record, which indicates that substituted service has been effected on the respondent number 1, comma, by paper publication, comma, as per previous direction of the court.
I'm grateful.
Whether this matter has come up on my mentioning an
This has not yet been called.
I apologize.
Oh, yes.
I-
Your instance, yes. What is that? You are the respondent.
My
You are the respondent.
respondent in this matter, my
Why have you mentioned it?
my lord, in this matter, by the last order of 6th of January, the
Why?
matter was mentioned, was taken. No, I had mentioned it, my lord, to file to which I have mentioned because some people have appeared.
Sujit Shah is you.
My lord,
They
sir,
mentioned, not you.
my lord, I had also mentioned my lord has directed me to file an appropriate application in this matter because for the respondent, 2 advocates were appearing, whom the petitioner, the respondent has not given any vakalatnama, my lord.
What is the correction you seek in the order? Which order?
That is
Order number 6
6 January. My
What
application
did
is on
wait.
6 January order, the recorded name of advocate is not correct, lordship. On that date, landed advocate of the respondent was not appeared. I have filed the affidavit of service. The name of the advocate for appearance in for the respondent is not correct, Lordship. Nobody appeared on that day. Another mistake of Lordship, the Supratim Dor and Ponsi Mugati was also not along with me in this matter. Their name is wrongly recorded.
অনিন্দিতা কি লিখে লিখেছে বলে তো এই অনিন্দিতা না একবার দেখা করতে বলে তো অনিন্দিতাকে এই ফাইলটা একবার the respondent advocates names were wrongly recorded. That is your grievance also, that they were not appearing.
Matter ex parte order was passed by my lord's court. Stay was granted.
Let us see just.
Also, earlier occasion when first order in the admission Lordship dated 11/12/2024.
How did their names come in and we don't know?
That is what we were wondering, my lord.
You are Dev Kumar Chandra and Dipanita Ganguly are not appearing in the matter at all.
No, my lord.
So must have some other in Bengali we call it Udor Pindi Udor Ghale has happened.
My lord, that is my
We'll record because they are also submitting that they did not appear. We'll record that these recording of these names was wrong.
deeply
None appeared for the respondent. That is Mr. Shah's submission also.
Matter was heard on 11/12.
Yes.
On this date also recorded.
Yes, some from some other matter this has been imported. And you appeared alone, not with Shukladin Dhar and Tosh. You have now instruction to appear for the
Yes, my
respondent.
lord. I have filed my Vakalattama and I have the instruction.
Now give your names for the respondents. Learned counsel appearing for the respondent submits that the name of counsel for the respondent were wrongly recorded in the order dated January 6, 2025. Since on that date, the respondent was unrepresented and the order was passed ex parte against the respondent. Full stop, next para. Learned counsel for the appellant supports such submission. Full stop, that apart, learned counsel for the appellant contends that the names of Mr. Supratim Dhar and Ms. Tanushree Mukherjee were erroneously recorded as advocates appearing for the appellant, whereas he, namely Mr. Sujit Shah, was the sole appearing advocate for the appellant. Push up next para. Since both parties agree on the erroneous recording of the names of the respondents' advocates, we hereby direct that it be deemed that none had appeared for the respondent on January 6, 2025, and the recording of the names of advocates for the respondent was entirely erroneous. Full stop. Insofar as the appearance for the appellant is concerned, let it be deemed that only Mr. Sujit Shah and not the other advocates whose names were wrongly recorded to have appeared for the appellant, entered appearance for the appellant on the said date. Full stop. This order be treated to be a part of the order dated January 6, 2025.
Kindly
My lord-
extend the time period for deposit of deposit.
My lord, one more
Yes.
submission may be allowed. to me.
Deposit of
Requisite Lordship for lower court record.
My lord, one more submission in this regard. My lord. They have filed a divorce petition before the Barakpur court. That is also pending, and they have not disclosed this in this.
that you have
matter.
to file an application. You
Paragraph
have
number
to file a
7,
separate application. You were served. Affidavit of service was filed. You did not appear.
My lord,
Your client was served.
sure, sir, but now these people,
We
these
cannot-
advocates were not appointed, my lord. That is what.
We have deleted their names. The effect
Yes, ma'am.
becomes that it was past expert. Despite service, none appears for the respondents. So how can you look into that even? You cannot
Paragraph
reopen.
number 7, kindly extend
Wait,
the-
wait, wait. Special messenger cost has also not been put in. Requisites you need not put in because they are appearing for the respondent now. So next para, arakta line add kore dao. Since the respondent is now represented through counsel, the appellant did not put in requisites for service of notice on the respondent. Full stop. The time for filing, time for depositing special messenger costs for bringing the trial court records is extended for a week from date on the prayer of learned advocate for the appellant.
That would be-
Yes. Whatever you have to say, you can file separate applications. We don't have it.
Deeply obliged.
You haven't remarried as yet.
No, my lord. Talks of a mutual settlement was going on, but they had come before this.
Wait. Not in formal certificate. There are certain defects. Please cure the defects. The impute decree certified copy has not been filed. Decree certified copy is not there. List of documents. Please check up the memorandum. আরেকটা line add করে দাও তো। The learned advocate for the appellant shall cure the defects as pointed out in the memorandum of appeal at the earliest. Thank you.
Number 5 here next.
Permission necessary.
My lord, this is my appeal.
Yes.
It ought to have been numbered, my lord, as FAT. Because this is an appeal under section 28 of the Hindu Marriage Act, where I am the wife and my divorce petition against my vicious husband, my lord, has been rejected by the
Look at
court,
adjectives.
court below. My lord, very, very vicious. This case, my lord, in fact,
No.
my husband in an
He's not represented. We won't hear
is
you
trying to embroil me in an NDPS matter.
even then.
Very
Don't use these expressions in court. They are undefended. The clients are not, the litigants are not here. Using these adjectives off the cuff, please don't.
I'm sorry.
If you are satisfied from the records, then we'll hold that.
I'm sorry.
But vicious husband, they can very well come up and say the very rude advocate of the appellant was submitting this. And you won't have any defense because you are not there. Just because they're litigants before a court of law, you cannot use whatever adjectives you like. Unless that is borne out by the records, we'll hear that when you hear the appeal.
I stand corrected, my lord. I'm grateful for
Please
the guidance.
never do that because we are a bit sensitive on that because they are undefended. They're not here.
No, my lord, I'm grateful for this guidance.
And you also have a responsibility to protect your other side also. His or her dignity. You have that responsibility. You are an officer of the court first.
Certainly, my lord.
And you also have to be a gentleman, like the movie. Very well. Learned, you have described the appeal correctly in the memorandum.
Yes, my lord.
We'll just check that.
It's been numbered as FM80, my lord. It should have been
Yes.
numbered as
No,
FM.
that has to be declassified, but we'll check up the memo. In the memorandum, you have to write memorandum of appeal from appellate decree. That's not there in your appeal. It's not mentioned. It's not like this, an appeal under section 20.
My lord,
So
we will-
we'll grant you leave your advocate and record to incorporate in the caption of the memorandum of appeal from original decree. You have to write that.
Right.
The present appeal has been erroneously classified as a first miscellaneous appeal, as rightly pointed out by learned counsel for the appellant. Full stop. We further note that the memorandum of appeal does not specifically mention the category of the appeal. Full stop. Accordingly, leave is granted to the learned advocate on record for the appellant to carry out the necessary correction to the caption of the memorandum of appeal during the course of the day, comma, incorporating the expression within double inverted memorandum of appeal from original decree. Double inverted close, full stop, next para. Upon the said correction having been done, comma, the file shall be sent down immediately to the department, which will reclassify the appeal as a regular first appeal and allot an FAT number thereto. Full stop. This much.
My lord, for the requisites and the other things, my lord. Would your lordship, my lord?
Let it be corrected because if you direct now, then the difficulty will be it will be in connection with the misappeal.
Very
That will create further complications.
I-
Let it be corrected. Mention that after that. We will do that.
My lord, then could your lordship kindly direct for the matter to be listed again upon, my lord, the necessary
Not right
corrections?
now. Let it be done first. If
Very
you give a date and if it's not done by then, again it will come, again it will go.
Very well.
Whenever it's done, you mention it, have it mentioned. Let it come up as to be mentioned. While mentioning, ask him to say that for this purpose,
Very
for asking directions.
grateful, my lord.
Yes.
I'm appealing for the appellant in this matter, plaintiff
Trial for the
appellant.
respondent number 1.
Now, this is for my lord, restoration of the appeal, my lord. My lord, it's dismissed, my lord, on 11th October 2023. My lord, there is a delay of 112 days, my lord. My lord, I have taken entire burden on myself, my lord. This is problem. My lord. There was, my lord, we missed the list, my
If
lord.
you have taken the burden on you, then we dismiss the appeal. We increase the burden. What is the burden? You have missed the list.
It was
Yes, what do you say, Mr. Dev, to this burden?
Only it is very difficult to submit anything
No,
because
no, he's trying to embarrass you by saying he has taken the burden.
he has
You
written,
go on undaunted. What is your
but
opposition?
he has written in the application that he was appearing in other court and he could not come when the matter was called on. But the application has been filed after 3-4 months.
Yes, because
No, no, then it's not a proper. Let us see the application.
Yes, sir.
It does not tally with what you are saying now. If you are engaged in another court, then you knew about the matter.
Yes, no,
That
what has
Immediately it
happened?
could have been filed, I can understand.
Yes, absolutely. Which paragraph?
I have specifically stated, my lord. Paragraph 8 onwards, my lord, and my lord, paragraph 14, my lord, is important because my lord, the appellant is my lord, it's an old man, my lord, he has given power of attorney to his son, my lord. So in that regard, my lord, some time has been my lord, consumed. My lord. That is the original fact, my lord, I can say. My lord.
Paragraph 7 he has written.
My lord, paragraph 14, my lord, is the delay, my lord. Why? Because the power of attorney has been given to his son. So my lord, it took some time.
You said you missed the list, which is not correct.
My lord, I
That
missed
is
the
not
list.
your ground here.
My lord, Lordship will kindly takes, my lord.
No, we took, Mr. Chattopadhyay, we took whatever you said on face value. But we see now that it does not tally with what you have written here. You told us at the outset that you had missed the list.
Yes, ma'am. It was.
But it appears from your application you had not missed the list. You are in some other court, which is also maybe a valid ground, may not be. It's not in law. But try to be correct before the court at least. What you have said, you are saying something else, that you have missed the list. Missed the list means I have not seen the matter in the list. Here you say you are in some other court, which is why it was dismissed. So that means you were there. And you have also stated inadvertent mistake on the part of the advocate in failing to duly reach the honorable court at the time, which presupposes you had knowledge of the.
Well, what has happened? Well,
No, we'll be stricter now. We'll look into it.
Well, only one thing, well, paragraph
No,
14, well, I have stated, well, that is the
whatever
main
you have stated, we'll look into the application as well. You are trying to mislead the court.
well,
Paragraph 8 he has said that he was engaged in another court.
See the next paragraph?
Yes, paragraph 8.
No reason.
well, I'll withdraw and well, I'll file a fresh.
No, need not withdraw, file a supplementary affidavit.
Yes, I'll file it. Well.
Prima facie, from the application, we do not find any reason, any sufficient reason for condonation of delay in filing the present restoration application. Full stop. On the prayer of the learned advocate for the appellant, the appellant is granted leave to file a supplementary affidavit upon service of an advance copy to the learned advocate for the respondent number 1, for the appearing respondent number 1, full stop. Let the matter be listed on February 10, 2025, next under the same heading.
I'm for the petition, but the appellant.
Why are you panting?
As I was in court number 11.
If you have a bad matter, even if you pant, we will dismiss it. No sympathies for panting. Yes.
But this is.
Take your breath, Mr. Dev. Second appeal has been admitted. Oh, this is the order 41.
This is order 41.
All right.
But this is the
No,
suit for.
One second. This is appearing under the application.
No, my lord, application section 5 was disposed of. Delay condon. Thereafter, my lord, this was mentioned for admission of appeal. Order 41. And there is an application, stay application also.
It was initially mentioned for order 41. Scored through written application. Anjun or Anjuna, we can't read. Banerjee advocate.
My lord, advocate on record is here.
Your correction, application.
Application.
The second appeal has not yet been admitted. The second appeal has not yet been admitted. Accordingly, let the matter appear under the appropriate heading on January 27, 2025, Monday. Because somebody may be watching the matter under the order 41 list.
My lord.
Your other side may be watching the matter. It has to appear in under the proper heading.
Item number 8 and 9, my lord, I am appearing on behalf of the appellant, both are analogous matter, my lord. The copy of
There is no caveat?
No, my lord. The
All
copy
right.
of the application has been served, my lord, but returned with the endorsement addressee moved.
Then you have to ascertain the appropriate. We had passed any interim order.
No, my lord.
No
The first
direction
time-
was given.
No, first time this is appearing, my
So
lord.
then we cannot take into consideration these unless there is a direction of the court, because this is a substitute of the rule which you used to issue. Unless we issue a rule, you cannot serve. I mean, that is not proper service in any event.
My lord,
But then you also have to ascertain the address.
the same address they are residing, my lord. They are brothers, my lord. Probate proceeding initiated by both of them, my lord. In my application, it was
Why two applications?
yes, my lord. In two probate proceeding was initiated, one by the appellant and other by the respondent, my lord.
Yes.
In my application, it was, my lord, not granted and rejected, and their application was allowed by the same judgment, my lord.
But then you had to file two appeals.
Two appeals have been filed, item number 8 and 9, my lord. One
8
is
and 9 action put it.
FAT 108 and FAT 109.
There's a condonation application also.
Yes, my lord. In both the item, my lord, can 1 is the condonation of delay
So Ms.
application.
Gupta will direct you to serve copies of all the applications on the respondent. Formally now we'll direct.
Yes, my lord.
Serve and come back. Let us hope for the best that it is served. The the two appeals, it's 8 and 9 action. The two appeals arise from analogous matters, comma, since by the same judgment but different deemed decrees, comma, the application for probate filed by the appellant was dismissed, whereas the probate application of the respondent was granted. Full next para. The appellant shall serve copies of Can 1 of 2024 and Can 2 of 2024 filed in connection with both the appeals on the respondent, indicating that all the 4 applications shall be listed under the same heading on February 10, 2025, when an affidavit of service shall be filed by the appellant. We are not noting those affidavits. So let us see what happens.
Great.
Fine.
My application.
Yes, sir.
CCTV.
Any resolution of
No,
this?
my lord. I'll indicate why. Lord, the receivers, their officer's report is there. Lord, this is a situation where my client does not want any kind of CCTV footages to be recorded because, Lord, unlike like an apartment or something, this common area is also used to access the kitchen, the toilet, the bathroom, all of that. So my other bedrooms, which are all there, so everything gets recorded.
But what about security?
So that's the only thing. Lord, if security is the concern, I'm absolutely agreeable to have security guards appointed outside. So, Lord, we've agreed to the 2 CCTV cameras or more if they want, facing outside the house, from where people can enter. There is a security guard which is placed outside the house anyways. There has been no complaint of theft or anything in all these years. From my childhood, there hasn't been. But if security is really the concern, then they can have security guards at every floor. At least a human being be able to stop someone who's trying to take a statue and run away. But this recording thing, my lord, my client's apprehension is out of the 5 brothers who live there, or who are brothers who together they own the property, only 2 live there. I'm the youngest who lives there, and there's somebody else. 3 live elsewhere. They have their own apartments in Rajarhat. So this will be a constant spying on me.
No, 2 of the brothers live here.
2 of the brothers, me and
one of them has installed the CCTV
no,
camera.
all of them have apparently installed the CCTV camera.
Just remind us, Mr. Banerjee, what was the genesis of this? The suit was by you.
Suit was filed by me on the ground that this is an invasion into my privacy.
Oh, suit was entirely on that CCTV.
Yes, suit is just in respect of CCTV. Title, ownership, nothing is there. The suit is actionable tort of infringement of privacy and nuisance. Suit is on that basis.
Where is the plaintiff? Let us see the
yes, plaintiff.
Their ad interim was refused, against which you have come up.
Ex parte ad interim was refused. So I was only praying for this, that if they want to file an affidavit, your lordship has given us an interim order. The order 39 rule 7 is also technically over because lordship's officer has gone and filed a report. So if they want to file an affidavit, they can do so in the learned court below, or my lord, I'm very happy before the bench. If they want to file an affidavit, they can do it here. I can have it thrashed out here. But we can go back also because if an ex parte ad interim, I'll show your lordship the plaint is at page 24.
When is the next date fixed in the trial court for the injunction?
The exact date. Jani.
Mr. Banerjee, all of you, all the respondents are appearing in the trial court also, the defendants.
Yes.
You represent all the defendants.
Mr. Banerjee also agrees, my lord, it can be advanced. We can give a put up in advance if he wants to take a direction for
something else also. Will
no, that's that's all right. That is there.
He cannot speak for you.
No, guy, I just
He's
heard
not,
him
he's
say
not.
it can be pre-put. That we can have it if he wants to file or if he's just okay with what is here. Prayers are at
The
page
suit
20.
is on privacy.
Yes. 29 are the prayers, Manoj.
Hmm. And what interim order did you grant? Let us check that.
Kindly have a look at it. Manoj. It's of 23rd of December 2024. Paragraph 4 is the most interesting. Plaintiff alleges that defendants have installed CCTV cameras within
The legacy from your family.
this.
Mr. Banerjee will just come back.
Yes, yes.
Messrs. Banerjee will just come back and. Yes, sir.
But paragraph 8 and 9 of the order that your lordship has already passed. However, we are satisfied that in the event the CCTV cameras are operating in the meantime, there may be a risk of intrusion into the privacy of the family of the
So
plaintiff.
you put a total halt on that for the time.
Yes, my lord. Now, my lord, there are two CCTV cameras which face the entry and the outside courtyard. That your lordship can direct them to, because they say
Which
we'll
are
have
those
access.
in the report? Which page? We'll refer to the report.
Camera 1 and camera 2, my lord. Page 6.
All right. Camera 1.
Primary focus towards the main gate.
So
Does
you
it-
don't have much qualms on 1 and 3.
1, 2, 1 and 2.
1 and 2.
1 and 2. Because it's focused towards the entrance. But there is a,
Oh, acha, acha.
your lordship will just picturize the house to be similar to what this High Court building is like. So the entrance, then there is a courtyard, and then there are corridors like this and rooms that run along the corridor. The rooms are also, mine is courtroom number 16, courtroom number 26, courtroom number 23. The bathroom is near
Thank
the
you
bar
for
library.
choosing 16.
No.
His room.
Always, will it has.
It has been historically
I should leave
your own room.
I've hardly an entry into this room. That is why it's
Yes, exactly.
that is why it is. So whenever I go from this corridor, and if I have to access any of the, and really, my lord, if security is the concern and intrusion is not.
Acha, please come to camera 5, camera 8.
Yes, ma'am.
Page 8. Camera C8. That faces towards the balcony and car parking area, faces outside the premises.
Camera 8.
8.
On the balcony adjoining the TV room on the first floor. Primary focus on the balcony.
It's outside the premises. Thus, it faces outside the premises.
My lord, this faces.
9 also car parking area and main entrance.
My lord, if your lordship looks at the picture, my lord, at page 15.
No, camera 8 is at page 19.
A and B, page 15 is the diagram of the house.
Okay, we can see camera C8 at page 19, the view from that camera. What is this? This is the common balcony.
This is the common balcony, my lord, with access to the rooms. And I've looked into it, my lord, these cameras that they have installed also have voice recordings in it. These cameras that are there, they have. Look, what I really don't understand is security is the concern. Otherwise, you're really trying to spy on your younger brother, what he does throughout, because you don't live here. If security is the concern at joint cost, security guard can be installed at the entrance of every floor. I don't mind. If he thinks that there are artifacts, when Mr. Gorai and Mr. Mollik had gone, I'm told that the artifacts which are in the balcony or in the corridors, you'll need about 8-10 people to carry them out physically. So if there is a human being who stops, and one thing that your lordships had opined on the first day that's actually stayed with my client, that people forget, cameras don't. Yes, your lordship had said.
Anyway, so but then
Look, I was
C1 and C2 you are agreeing?
Yes, I am agreeable to more cameras being installed anywhere that faces the outside. If security is really the concern,
so then that is all about it. And then let us hear Mr.
Yes,
Siddharth.
yes.
Yes, take your seat.
Yes,
Kindly
Yes.
take me the report of the learned
Yes,
special officer.
report.
Millard 1 and 2, Millard, as I now understand, there is Millard no quarrel.
No quarrel.
Then kindly take Millard camera 3. Millard, this is focused towards common corridor area, vacant space. Kindly also take Millard the plain side by side. Millard, that would help us. Millard, what was the allegation? Millard, that was the foundation of the suit. Kindly take Millard can 2.
Page 25.
Page 24, Millard, is the plaint.
Yes, 25 the pleading start.
Kindly take Millard page internal page 6, paragraph 10 of the plaint.
Yes. Internal page 6.
I'm sorry.
No.
Kindly allow me a moment's time.
Para 10 is internal page 4.
Kindly take Millard can 2 internal page 6.
So internal page 6 is the internal page of the plane.
No, no. No, my lord, can 2 page 6. Para 10. Paragraph 10 of can 2. No, no, not from the plaint, my lord, from the application itself. No, reproduction from the plaint.
Yes, 10.
The respondents in collusion and conspiracy with each other, starting from sometime, etc., installed 9 surveillance cameras in or around the suit property without the consent. The petitioner, being one of the trustees, was not even informed. The respondent regarding the installation of surveillance cameras, no consent was ever obtained from the petitioners. Prior to installing, the petitioners neither have access nor the administration over the surveillance cameras. So, my lord, he wants, if I go by paragraph 10, my lord, access to the cameras. My lord, you are agreeable to that. Then, my lord, kindly take paragraph 11. My lord, these are his allegations and his problems. The problem particularly arose about 5 surveillance cameras. My lord, there are around, my lord, 15 cameras, out of which, my lord, he is, my lord, not agreeable with, my lord, continuation of 5 cameras, which are installed in the interiors of the suit property. These surveillance cameras are dome-shaped surveillance cameras that have motion detection features as it appears from the bare perusal of the said CCTV cameras. The 5 surveillance cameras are installed inside the residential building in the first and second floor.
Plaintiff's allocation means where they are presently occupying. It's a joint property still otherwise.
Yes. By my lord, internal arrangement, my lord, they are occupying, my lord, some of the rooms.
Yes.
The 5 CCTV cameras detect and remain almost having a fixed focus. This is his allegation. At the doors, windows, and the interiors of the plaintiff's allocation, thereby severely infringing the privacy of the petitioner and his wife, both of whom are senior citizens.
Yes.
So, my lord, we can install the cameras in a way. Firstly, my lord, we are agreeable to remove all the cameras which have, my lord, rotatory motion. We will, my lord, install fixed cameras which do not move and have, my lord, a fixed focus. And, my lord, we are agreeable to ensure
fixed focus on their rooms. They are agreed with 5.
Correct. So, my lord, these
which 5 you cannot gather from this?
My lord, that we can gather, my lord, from the report. But once we, my lord, read the allegations and then come to the report.
We will do that. Yes.
So, my lord, so far as, my lord, his access to the cameras and, my lord, the recording cameras, my lord, he is, my lord, we are agreeable to give him, my lord,
you are agreeable to
fullest
put in
access.
fixed cameras.
Fixed cameras, which will not, my lord, if I borrow the language.
Sound recording?
My lord, will also give up that. Oh, that I'm told, my lord, that is not there in fixed cameras.
Not?
Fixed cameras do not have, my lord, this feature. Now, my lord, they will not, my lord, if I may use this expression, peep into, my lord, their occupation. Not at all. My lord will ensure that the learned receiver can go, special officer.
But there cannot be a constant vigilance on that. We cannot have a surveillance on that because we cannot implement an order which we cannot, we cannot pass an order which we cannot implement.
My lord, if tomorrow after installation of a fixed camera, which do not, my lord, at all peep into their interiors and all.
At the installation point, you are agreeable to have it.
Yes. Then, my lord, if I do some mischief, my lord, even if I, my lord, substitute them.
So that's a different cause of
action. He can then come up again. And, my lord, I won't be having a.
So what are the locations? I mean,
I tell your lordship, then kindly take, my lord, paragraph 12. My lord, I just show your lordships all the allegations.
Yes.
Surveillance cameras are for securing property against any outside.
The rest are the violation of previous sentence.
Correct, correct. Now, my learned friend was suggesting that, my lord, there are busts, marble busts, and, my lord, other, my lord, artifacts and etc., which are so heavy that, my lord, a single
Para
person.
14 also they say the 5 surveillance cameras.
Correct. So, my lord, they are agreed by installation of 5 cameras out of 15 cameras. My learned friend has not today indicated before your lordship, my lord, which of those 15 cameras, my lord, which are
Is
those
it
5
consistent
cameras?
with the plaint case? Let us see the plaint case.
Yes,
also,
my lord, the
because
plaint
emanates
is at
from the
page
plaint.
24.
You also have to look into the, yes, 5 cameras. Para 13.
Yes, yes. Similar verbatim reproduction.
Yes, 5.
From paragraph 12 onwards.
Yes, yes.
It's just reproduction
Right.
at page 27. So, my lord, we don't have any difficulty, none of us, my lord, with regard to 10 cameras. My learned friend should indicate, my lord, which are those 10 cameras with which, my lord, he has no issue. My lord, he has not done that. He cannot improve on the case, my lord, which, my lord, he has made out in the plaint. That's, my lord, first. Second, now, my lord, kindly turn to the report. Keeping in mind, my lord, let us keep in mind, my lord, the allegations. My lord, first two
What is
cameras.
the
my lord-
injunction they have sought? The mandatory injunction they have sought to remove the surveillance camera. They
Yes,
seek
my lord,
removal
that is
of all.
not, my lord, in consonance with the averments and allegations made in the plaint.
No, were there only 5 cameras at that point of time? I
No,
mean,
no, no. My lord, after that, my lord, you have not installed any, my lord, other camera. All these 15 cameras were there.
yes, they have admitted that 9 surveillance cameras were there. You said 10.
I say 15.
Nine,
Report says 15.
9, and then 5 more. Paragraph 8 and paragraph 9.
Acha, 9
And
plus
we have
5.
can 3. I haven't seen it. Mr. Gorai tells me we have can 3 before your lordship.
But
saying-
it appears. Para 8, you say the defendant sometime in 2022 installed 9 surveillance cameras
Yes.
in and around suit property.
Yes.
The problem particularly arose about 5 surveillance cameras
Correct.
which are installed in the interior.
So let us know, my
It
lord,
appears
which
that
are-
those 5 are within those 9.
Yes. Now,
But
within those
they say there are 15.
My report says
we have
15.
can 3, which he doesn't have a copy of here, that they've installed additional cameras afterwards. Not all this will have to come in trial, but my suit can't go. My suit is on the basis that there can't be any surveillance cameras
In
at
the
all.
suit, you have complaint of 5 cameras only.
If your lordship, and let him finish, otherwise I can just indicate if your lordship looks at page 29.
And they always knew, my lord, that we have installed 15 cameras. There
Now,
are
the
communications
objection is
exchanged.
with regard to decree and declare plaintiff and persons claiming under him has the legal equitable right to enjoy
Yes,
the
but
suit property.
This relief is not based on any pleading because your pleading says only 5.
Grateful.
But if your lordship looks at 10,
Of the plaint.
Para 10.
para 10 of the plaint. So my ground in the
This
suit,
qualifies. I mean, this is in the
But this
continuation
qualifies-
of 9.
yes, but only with respect to any surveillance camera inside at all is nuisance for me, an invasion of privacy. Today there is 5, tomorrow they'll make it 2,
But
after
the
they'll go to
appellate
2
court
more.
cannot go beyond your prayer in the plaint because
No, I am not requesting your lordship to go beyond the
Your
plaint.
plaint case is
My-
says 5 cameras.
My learned friend is restricting my plaint only to 5. The number was 5. My objection is intrusion into privacy.
Yes,
it-
but
it
we
is
cannot
not the-
pass orders on something which is
But
not
now your
happening
lordship is
premise
now, so in the suit now, the object of 39(7) has been complied with. Now your lordship finds that there are 15 instead of 5. So somebody who had an objection with 5, it can't be said that with 15 he won't have an objection. So to restrict my suit only to 5,
Well,
where I've said that you
so,
can't.
yes, we'll let him complete.
Yes.
Yes, Mr. Banerjee, what is?
Yes.
Yeah, you point out from these from the special officer's report,
My lord, first
which,
two
which are
cameras,
the
my lord-
ones which are not offending.
Yes.
1 and 2 they have considered, so
Then
we are
my lord,
not.
kindly take 3.
Yes.
Primarily focused towards common corridor area and vacant space upon entering the residential building. Kindly, my lord, also have a look at, my lord, page.
But the common corridor is also used by them.
Yes.
Their guests will come and go by that common
Remember, my
corridor.
lord, the allegation that, my lord,
What is the
camera-
use of putting in common corridor cameras?
I'll show,
I
my
mean,
lord,
if
from
all
the
the corners do not agree, Mr. Banerjee,
my lord, I'll show
we
from the-
cannot force. You cannot
I'll
force.
show from the report itself, my lord, what is the necessity of installation of those cameras.
What is the
My lord,
necessity?
this is one of those buildings which is, my lord, loaded with, my lord, artifacts and
Have
my lord,
security
plates,
guards.
everything.
Have security
It
guards.
should be something, my lord, if I may, my lord.
At the entrance, have security guards.
This is, my lord, absolutely preposterous, my lord, for my learned friends client to
Why?
say that, my lord, they are comfortable with, my lord, my lord, security guards, my lord, sitting in the corridor, my lord, looking at everyone, and CCTV cameras, my lord, instead of security guards, if are installed, my lord, that will breach their privacy. My lord, they are comfortable with, my lord, the
Camera
gauges.
recording, people may be very uncomfortable with
Let the
camera.
recording be with him only.
You have access.
I won't be having access, my lord. That would be put under lock and key. My lord, 2 locks, 1 key will be with me, 1 key will be with him.
Locks to what?
My lord, this central monitoring system.
There are not physical locks to that.
Yes, we can put, my lord, we can put it in a box and we can lock it so that no one can have access. My lord, in case of any
If
theft,
they only have access, they'll turn
both of
off the
us.
cameras.
My lord, both of us, 1 key with me, 2 locks, 1 key with him. My lord, we are agreeable to everything. Even we can't see them through the cameras. My lord, I'll come to that. Firstly, my lord, let us have a look at the report. My lord, we are agreeable to everything. My lord, it's, my lord, it shocks one's mind that, my lord, they are not.
So what's the use of putting in cameras in the
Kindly
common
see, my lord,
corridor?
the photographs, my lord, which the learned special officer. has,
Common
my lord.
corridor is actually a common corridor, basically.
My
I
lord,
mean, so if
kindly
one
take,
of the
my lord,
corners have an objection, Mr.
not touching.
Banerjee should not put in cameras in the premises. Cameras in the premises. These are not
He is
public
not
premises.
comfortable with the camera for some other reason. I do not want to get
What,
into that.
whatever may be that is.
Do not want to at all.
Mr.
get
Banerjee,
into
we
that.
don't have any business looking into any other reason.
Absolutely. Kindly
What is
take-
your business in putting in cameras for
Milord, that
looking into
answer
their
is there in
personal
the
life?
report, Milord. Kindly just have a look at the photographs.
Let
and-
us see the photograph, page 18 onwards.
Yes. Milord, my brief is not paginated. Kindly see, Milord, there are small artifacts also which are, Milord, valuable. And, Milord,
Maybe.
these are all, Milord, curio things.
Put in security guards, Mr. Bennett. Don't have cameras in the. I mean, these are.
Security guard itself might be a threat because of, Milord, the treasure.
Will
that
not
we
put
have.
security guards on every floor. Definitely not. There'll
Every
be
floor,
security.
Milord, is loaded with this, Milord. Even one can carry something
One
in
has to
pocket.
enter through the gate only.
Milord, one can carry something in pocket also, Milord. There are small miniature things also.
Me.
Kindly, Milord, have a look at the second page of the annex, third page of the annex.
Since when are they here? They're from prehistoric times. Has there ever been any theft? What is the apprehension? Sudden apprehension?
Milord,
And don't lodge a diary tomorrow and say that there is an apprehension.
No, Milord, that don't happen. That don't happen. Milord, there are, Milord, extremely valuable watches. Milord, extremely valuable, Milord.
Watches or clocks.
Watches.
Watches keep in the rooms.
Milord, we don't have any other space. Milord, it's loaded.
Rent a space and put it there, Mr. Bennett.
Milord, these are our family properties. Milord,
Your family properties, put it in a locker, put it in some storeroom, have a lock to that, share it. We put our ornaments in lockers, not put them on the dining table or on a common corridor.
There is a hall which is also, Milord, Milord, filled with, Milord, these, Milord, kinds of items. And, Milord,
CCTV camera is not.
Milord, he is not comfortable with, Milord.
Nobody would be comfortable.
CCTV cameras, Milord, peeping into his room, Milord, washroom,
not necessary.
kitchen.
Not
That's
necessarily.
his allegation.
Mr. Banerjee, I may not be comfortable with a camera. I mean, if I live in a premises and there's a common door which leads to my room,
Provided one can
my
see
guests will come over that. I may have privacy. I may want you not to look at some of my guests. I have that right. I may meet people clandestinely without you looking into them.
Milord, I won't look at that.
We'll have to direct you to put your eyes shut all the time.
Milord,
No cameras. Why? How can you put in cameras in common hallways or common corridors?
Only in the corridor.
And one of the
inside the
even if
rooms,
one of
Milord.
the corners don't agree, they have their right to privacy.
Milord, I'll come to the corner.
They have a right to privacy on every aspect of their life, Mr. Banerjee. Whoever they want to meet, whoever, unless they do something illegal, you cannot have them watched by a camera.
Milord, if a guest comes, Milord, if I am there in the corridor, I can see him. I do not need a camera, Milord, to see him.
Three of you are not there. You have no business to put in CCTV monitors.
So, Milord, my instruction is, Milord, all of us, Milord,
All
stay
the
there.
brothers.
That's Milord, my instruction is. Rather, his son, Milord, does not stay there. Milord, who is
His
the
son
triggering
is not
factor?
not
He's the
important.
triggering factor. Milord, let us forget that.
These
Kindly
are
take, Milord,
allegations.
the report. Kindly, Milord, take the report. Kindly see, Milord, he is not.
We are taking the report. What
Yes,
about
Milord,
that?
3, camera number 3. Milord, these, Milord, common corridor. Milord, I am putting it aside, Milord, for the time being. Then, Milord, take camera number 4. This is, Milord, staircase leading to the second floor.
Yes.
He should not have a problem, Milord, there. And more so when, Milord, we are agreeable to ascertain.
Common corridor area and vacant space. Number 3.
4. 3, Milord, I am keeping aside for the time being. 4.
Staircase leading to. They live on the second floor.
They live on the second floor.
First and
second. And Milord,
You live on which floor?
ground first floor.
Ground and first.
First and second. Everyone stays, Milord, in the
First and second.
Rooms are, Milord, particularly allowed.
All right. Next.
Then, Milord, 5. Milord, this is common corridor. Milord, 3. Milord, this is the room where, Milord, the most valuable, Milord, things are, Milord, stacked.
C6.
C6.
Nobody lives there.
No.
That is under lock and key or what?
As of now, under lock and key.
Who is in control of the?
Everyone.
Next.
Then, Milord, 7. This is common corridor. Milord, I am keeping the common
There
corridor.
are so many
cameras
common
aside.
corridors. Yes.
Yes. Milord,
C5 is also common corridor.
2 common corridor. I am sorry, Milord, C5 common
C5
corridor.
common corridor.
C7 common corridor. And then, Milord, C12 is common corridor. That's the third camera in the common corridor. 13 is common. And that's it. So, Milord, 4. So, with regard to the rest of the, Milord, 11 cameras, Milord, there should not be any difficulty. Now, so far as these 4 cameras are concerned, Milord, let this
No,
camera.
C13 is also common corridor.
Yes, Milord. C13. Yes, 12, 13. Milord,
13.
5, C5, C7, C12, C13. 5, 7, 12.
Others are either facing
Staircase,
outside, staircase,
parking
or Gorachand
areas,
Mollik.
lawn.
And one, two focus on
Oh, that
in the
hall.
hall.
Yes. Now, Milord, so far as these 4 cameras are concerned,
Yes.
Milord, our proposal is, I think, Milord, that sounds also, Milord, logical and reasonable. Milord, fixed cameras would be installed. Milord, these cameras won't be having, Milord, any sound recording system. Milord, there won't be, Milord, any access to, Milord, the recording of these cameras through anyone's mobile.
Regarding the common corridor cameras?
Yes. Nobody will be having an access through mobile or any device. Milord, there would be only one, Milord, central monitoring system, which would be under lock and key. 2 locks would be, Milord, put. One key will be with us, one key will be with them. If in the, Milord, event, Milord, God forbids, anything happens, Milord, both of us, Milord, agree to open it and see the, Milord, monitor, the recording. And now coming to the co-ownership, Milord, he cannot claim himself to be a co-owner. Milord, there are, Milord, law points on that. Milord, I need not trouble if Milord invites me, Milord, I can just indicate.
Indicate?
Yes. Milord, there was a trust. Milord, created by Gorachand Mollik, Milord, who, Milord, gathered all these treasures. Now, Milord, Gorachand Mollik, Milord, firstly, Milord, executed a deed of trust where, Milord, he was not there. Then, Milord, that trust deed was revoked and again, Milord, not revoked, Milord, modified. Milord, once a trust is created by, Milord, someone as the owner, Milord, giving it to the settler, Milord, to the trustees, he does not retain a right, Milord, to again take it back and, Milord, appoint, Milord, further trustees. He does not have the right. He ceases to have that right.
That has been done in their favor.
Yes. So, Milord, this modified trust deed, Milord, that's, Milord, void ab initio. Section 78 of the Indian Trust Act, if I am not wrong.
Mr. Banerjee, as you place the list of cameras, none of them apparently faces directly towards their room. No, but the common corridor, some of the common corridors cameras must be doing that.
One may, Milord, have a look at their, Milord, entrance door, the wooden door. Milord, there are cameras which also will look at our doors also. Milord, we'll remove all these 4 cameras, we'll fix fixed cameras, install fixed cameras, and, Milord, the monitoring system will be like, Milord, we have suggested now. Then, Milord, there is no breach of privacy. Milord, if he is not comfortable with that also, then, Milord, something, Milord, foul is.
Yes, you're done.
78, Milord, I'm not showing to your lordship, Milord.
78?
That trust act.
No, that is on the merits. We have not yet gone into that stage.
So,
we not go to that extent. We wanted
something, Milord, which does not like.
Anyway, we won't go into that. But yes.
Could I just deal with that in 2 minutes? The purpose, the avowed purpose appears to be security. This query from the bench is naturally not answered, that these artifacts, statues, watches, all have been there from prehistoric times. One complaint of breach of security, not there. It's possible that they're anticipating it. Now, if they're anticipating it, then what is the point of having recording of cameras? Well, the pictures only show the location of the camera. What the camera looks into considers a situation where I am sitting in a
the
drawing
pictures
room.
probably have the camera views also. No, the pictures have camera views.
Pictures just the cameras.
No.
If
Come
your
to
lordship
page,
looks at
page 23, 24, all have the camera view.
C8.
No, from at least
no,
all of page 22, 23, all it's very evident.
So here, if your lordship looks,
cameras were run by the learned special officer, and, Milord, photographs were taken from the monitor.
Yes.
So if your lordship,
you can see the special officer also.
Now, if you
so there is ample proof that this is the camera view.
22 bottom, your lordship will see a lot of.
Yes, that.
No, please have a look at that. Let us say we have a look at that, the last picture. If I am sitting in my drawing room, why would I need to be recorded by my other family members? What is the point of having, if I'm in a corridor and I'm walking up the steps, who I'm walking up with? Who's coming down with me?
So, Banerjee, the cameras were there from 2022, which is the logic of the learned trial judge. At the identity stage, why should we interfere at all? Because this is one of the probable possible views. That from 2022, the cameras were there, you file the suit in February 2024.
Every day that the camera runs. there is a
Yes,
breach of
but for
privacy.
these 2 years, there was no breach.
True,
The
but-
same thing, there is no change of circumstance.
Well, a change of
What is
circumstances,
the,
or
the
additional
compelling
camera.
urgency to grant injunction?
That every day I'm getting recorded. Every
Yes,
day, every
you were
day.
being recorded from 2022.
The additional cameras that get installed.
No, that is not
in
there in the
five-
pleadings. There is
I'm
no
sorry?
pleadings on that.
No, the paragraph section 6 and 7 of the plaint. Today this
There's no
court
pleading
has today the court has found that
But
there
there
are
cannot be any evidence beyond the pleadings.
no evidence beyond pleading. I'm saying that
This is a
in
piece
my
of evidence at best.
I am saying 39.7. That too, if I bring him into the box and all of that. Today there is a security camera that looks into my corridor, that looks into my drawing room. So
Not
if
your,
everybody's, without a doubt. The question is, why would I need to be filmed every day? If there is a security concern, they can have security guards. Why not security guards, and why have
Banerjee,
somebody
what's the
record
difficulty
me?
if there is a camera on the common corridor and the common hall? Because you can very well do whatever you like to do in your private room.
When that is the thing, the impression that he's been given. I had requested Mr. Gorai also to, but considers this premises as so common corridor. Let's say the common corridor from this common corridor is running adjacent to all these buildings are getting filmed.
Because we are the ad interim,
So
we are at the
expert-
appellate stage,
That's
looking at an ad interim order, in which reasons were given, which reasons are one of the possible views. From 2022, you sat silent. So no ad interim injunction now.
So my
We'll hear them
only
now.
thing is that those two
Why is that
cameras,
fair?
those now that your lordships have found that there is a breach of privacy, every day that it runs, there is a breach. I could have gone and filed a suit today also.
We have not conclusively
No,
found
of course
anything.
not. That's
Everything
that
is ad
much-
hoc.
Of course. But the fact remains that I have been able to at least establish that there are these many cameras that are running. These cameras are running and filming the inside of the house.
Yes.
There is absolutely no basis to come and justify to the court.
Not only yours.
Not
I
mine,
mean, they also
everybody.
have a right.
But even if I'm a ranked trespasser, this aspect of the trust deed, one will have to
Because
challenge.
into your room, we could have understood. But Mr. Banerjee, why do clandestine things in public?
Not clandestine. If I may just put this question in a different way, why do I need to be recorded in my own house? The common room is the drawing room is the common room. The common corridor is a common corridor. If I'm coming up by
Everybody
steps,
will be recorded. You are not being isolated for that. If there was an isolation, we could have understood.
So I live,
Everybody, they will also be recorded.
it is possible that 5 people don't have a problem with their privacy being breached, primarily because they don't stay here.
But privacy, the perception of privacy, Mr. Banerjee.
So I'm keeping it as wide as possible.
Yes, that that's very fluid.
Yes, I'm keeping
and
it as wide, as
relative.
fluid as possible.
Privacy of the notion of privacy is very fluid. Your perception can differ from mine.
Very different. Absolutely.
So we have to draw a line somewhere.
That line that your lordships might consider drawing is where I am being recorded. This is not a case where there's a security guard looking at me. There my privacy is, because everybody is being looked at. There is a man who's there. Why would I want to be recorded in my common areas, in my balcony, in my corridor, when I'm getting out of my room, going somewhere else? What is the point of
The understanding is we are hearing the appeal itself, because we'll close the appeal.
Yes.
The appeal.
Yes. And then we can.
Otherwise, there would be no use. Whichever way we go, I mean,
Yes.
nothing will left for.
So, today, privacy has been understood to be a right under Article 21 now.
Yes, no doubt.
Now, if the only question, what I'm given to understand from what the respondents argue, that security is the concern. Nothing has been, they have not been able to show that this security has ever been breached. There has ever been any complaint of threat. Why a security guard is not enough? Why a security considers this? Why 2 CCTV cameras or 10 CCTV cameras which look at the entrance is enough?
Security versus privacy. Security আরেকটা ব্যাপার আছে, সেটা হচ্ছে আমরা অ্যাপিলেট করি, যেটা ওর এগেইনস্টে যাচ্ছে। সেটা আমরা অ্যাপিলেট করি এখন কোর্ট একটা ভিউ এক্সপ্রেস করেছে যে তুমি 22 সাল থেকে কিছু করোনি, সুতরাং এখনই প্রেসিং কোনো আনসার ছিল এবং গ্রান্টিং ইনজাংশন ফাইনাল সেটাও মাথায় রাখবেন। আর প্রিভিয়াসিটা ডে টু ডে ইনভেশন সেটাও বলছে, সেটাও আছে। Yes.
When I'm coming in.
Yes.
Your Lordship has found that my stand has consistently been, and I'm that's why okay with C1, C2, and C3, which faces the outside of
C3 also.
No, C1 and C2, sorry. Any number of cameras. Not if they want 20 cameras, if they face the entrance, the exit, and where people enter from, I have absolutely no qualms. Milord, I am too.
Mr. Banerjee, if you have no qualms regarding who enters and who exits the property, then what is the qualm regarding the corridor? Because only those who enter and exit, they only use the corridors.
If I want to check, because CCTV cameras as opposed to a security guard, if someone is stealing it and running away, CCTV cameras won't get down and physically stop them.
No, the picture will be there.
So picture
all
will
the
be
recent,
there. That's right.
Recent news reports are all on basis
All
of
on-
CCTV.
That's
not security guards.
That's right. So, Milord,
And security guards compromise the
so
people.
if I am to look at this aspect of it,
You are safer in the hands of a CCTV camera than a security guard.
so see, that's why I'm saying, Milord, if security is the concern, have security guards that have CCTV cameras that point towards the entrance and exit of the house. Why are you
Direct them
filming?
to have security guards that point the cameras towards the security guards.
No,
That would solve all problems.
In fact, Milord, in one of these
No,
residential
privacy would be,
premises, I
the
had gone
privacy of
to-
the security guards then come before the court for privacy.
in one of these residential newly
Every scratch they
residency had
have,
come,
they'll
the security guard is sitting there. He's doing something with his hands. He's getting filmed. The entrance was
so many houses, so many residential complexes.
in one of these old ones I went
And
to,
the security guards being
and the gate has been left open. Off late, you'll also have seen. But here I'm saying that if that is your concern, you want to see who has come, who's walked out with it, then keep it outside. Milord, I understand what is probably
if
troubling
we
the court.
the trial court, we could have a sermon on privacy versus security.
No, I understand what
right?
is troubling the court. That
But
why did I come from
the scope of
2022?
the appellate court is very
Very restricted. Milord, your lordships, what is troubling is that this happened in 22. Why did I come
No,
now?
no, not us. The trial court was troubled, and trial court is entitled to have a view.
Yes.
One of the possible views.
Yes.
Settled. Appellate court can't interfere with one of the possible views.
No, that possible view, if your lordship looks at the rejection, it's only on the ground that have come late.
Yes.
But that coming
At the administrative stage, that is one of the most important grounds.
But here, if I can show that let's say for an example of partition, it's a continuing wrong, it's a continuing cause of action. I come and ask for an injunction in a partition suit the day I come to court. Section 22 is there. In a suit for partition, court doesn't refuse, and your lordships have interfered with these orders. Then in a suit for partition, my right could have accrued on first day. But I come every day that wrong happens. This is where, in my understanding, and I respectfully submit, the learned trial judge has gone wrong. Every day the privacy is breached. Every day that urgency arises. And the ideal example of that is a partition suit. If I can apply section 22, every day's infringement is a privacy. Well, the cause of action to sue and the invasion or the infringement are two different things. The infringement continues in my respect. That infringement can today, that's why a lordship has passed that order. Of course, both of us understand that that is not a finality.
But even then, yes.
But even then, this court has found that there is a prima facie intrusion into privacy. And there is nothing on record today to show that any theft has been occurred, any situation has arisen which warrants common areas to be filmed. I don't understand, what is the point?
No theft. Don't know.
Don't understand this Mr. Banerjee's submission, that suggestion rather, that it will stay locked. I will have access, you will have access. But he still has access. I'm still getting filmed. And we'll have access only when both of us open it. But then what is the point of having a CCTV camera inside the house? If you want to see if really the purpose, if I may say this, the court is not oblivious to what is actually happening.
Locking, unlocking is immaterial.
Is immaterial.
Because
and the court is not oblivious.
If either of you can lock it off, then there's no use putting
and
it there.
what will I do with an injunction like
if
that?
you cannot,
then what is the point?
Remains, yes.
Exactly.
The privacy angle still remains.
Still remains. And the other that suggestion, it sounds that he's saying I'm conceding to everything. Then concede to this. If you want to have people or identify people who are coming in to steal or taking things out and going away, you have 10 CCTV cameras in the entrance, exit, the courtyard. What is the point of trying to film me?
So we'll close arguments now. Yes.
Close.
Mr. Banerjee, you're going to say something regarding the locking.
Yes. My lord, if something
By
happens.
locking, you mean that both of you can lock it off.
No. My lord,
Then
that-
still it remains. Their cause of action remains.
Right,
Whatever
my
is their cause of what.
If something happens, God forbids, then my lord, the investigating agency may come and can my lord see my lord the film, what has been my lord filmed. That can
So
be
that
seen
can
there.
happen
And,
even
my lord,
when
in my house
somebody
also, my
comes
lord,
in.
touch it, my lord, till today there has been no theft. But my lord, I have installed CCTV cameras. Prevention is possibly
That
my lord,
Mr.
better than
Banerjee's
cure.
house must have and my house has.
So my camera is not.
But we don't
So, my
have.
lord, that, my lord,
But none
no
of our
theft has
kosher.
taken place.
First of all, I'm a licensee in my house. So my father is the owner. So I don't have a right there at all. So and in Bijon Bhavan, where the official residence, it's a public place.
Both of us are willing.
Residence, but it's a public place all the same.
Now
all
that,
judges stay
now
there.
that he's
You
brought
don't
in.
have any say in that also.
Well, now that he's brought in the example of my house, your lordship is aware that it's commonly shared.
No, but it's our notions, as we said. I mean, our notions. If one
No,
of the
but-
owners have as an
If
objection,
somebody
we'll have to
puts a
consider that.
CCTV camera that overlooks
Recorded,
my
and
balcony,
something happens,
and that
one
gets
can come and
recorded.
see what has happened.
We
There
have
will be
security
something
guard. We
recorded.
can have CCTV cameras that faces the courtyard.
Milord, I'm comfortable with the gaze, Milord, inquisitive gaze of a stranger, not comfortable with a CCTV camera which no
Milord,
one
it's
can see.
not very different from a security guard sitting there and me getting
He
filmed
himself
all
would be a threat
24
to
hours.
us.
I'm getting recorded for 24 hours.
What will be the comfortable hours for you? The security guard will look at me for 10 hours.
No, security guard, like it
I'm
was for the-
comfortable with 10. He's
No,
comfortable
this-
with 8.
Well,
So let it be.
The security guard will have no memory. The CCTV camera has especially these security guards have no memory.
After all this
At least
Don't underestimate anybody. Judges, including judges.
No,
We
these are
sometimes do have memory.
these are the respectful submissions.
We will close arguments. Hearing is concluded.
Appeal.
On consent of parties, the appeal itself is taken up for hearing. Push up hearing is concluded, and the matter is reserved for judgment.
No, the interim order is expiring on the 31st, but I think that will be.
Till Milord delivery of the judgment, Milord ignore that.
Yes, yes.
And the interim order granted earlier is extended till disposal of the appeal. That means. Oh, sorry. 31st Next. ভালো জাজমেন্টের স্কোপ আছে।
বলা হয়েছে।
11, my lord, I am for the appellant, my lord.
This
My
is
lord,
items 11.
My lord, the respondents have filed an affidavit in opposition, my lord. I would pray for a week's accommodation to file my reply, my lord.
Filing my affidavit in opposition. my lord.
Right. Affidavit in opposition filed to be kept on record. On the prayer of learned counsel for the petitioner, the time for filing reply is extended for a week from date. The matter shall next be listed on February 5, 2025 under the same heading.
I'm grateful, my lord.
Thank you. Who is for the appellant?
Loss, I am appellant.
Why didn't you appear on the last occasion?
Loss due to mistake.
Missed the list or something?
May I put my affidavit in opposition?
Opposition, yes. What about your reply? Yeah, okay.
Not necessary, lordship. Opinion service loss.
I reply to this.
May I?
Probate has been granted. This is injunction.
No, probate was granted. Yeah, I prefer an appeal in the.
What is the application for injunction?
Injunction loss.
That is what we said.
Lawsuit only innocuous player lawsuit, not to create any third party interest in the meantime, and not to change the nature and character.
Yes, how do you object to this? You'll change the nature and character during pendency of this.
No, my lord, I have already filed an application for vacating the interim order that we have got.
What is your ground? No, we are taking up the injunction application itself.
No, my lord. Today, okay, my lord, this
Your ground in the vacating and injunction will take up together. We are taking. So what is why not grant injunction?
What has not been pleaded in my affidavit in opposition? That is, my lord, the date when my lord was pleased to pass the interim order. Prior to that, my lord, he has deposited the fees for the my lord obtaining the That is a 50,000.
We have not stated that is a precise
I
reason.
think my lord,
The order.
no.
That is the
was not
precise
stay.
reason why we don't grant stay in connection with this.
No, I am only praying injunction, not stay.
Please
And also
come
lawsuit
to
was
the
not
order dated 3rd of December 2024. That is precisely why we don't grant stay. There is no stay to the probate decree. You get your probate, but don't transfer, alienate, etc.
Yes.
Encumber, whatever.
There are two.
Extend that order till disposal of the appeal. And you are appearing for you are the sole respondent. So that will be dispensed with. You will file paper books, the usual direction.
Call for the special message with special message.
The usual directions, yes. Yes, what do you say?
1 minute. Where is the order?
We are granting injunction.
Is the order time? Application করছে
The affidavit in opposition and affidavit in reply filed to be kept on record.
no reply lawsuit.
Oh, you have not filed.
Service.
The affidavit in opposition filed to be kept on record. Full stop. Upon hearing learned counsel, we are of the opinion that since both questions of fact and law are involved in the appeal, the appeal requires to be heard. Appeal is required to be heard on its merits. Full stop. Next para. In the event the respondent creates any third-party interest or alters the nature and character of the property, in the meantime, the same may have an adverse effect on the outcome of the appeal, insofar as the corpus of the disputed will is concerned. Full stop. Accordingly, we are convinced that a sufficient prima facie case for grant of injunction has been made out. Full stop. Also, the balance of convenience and inconvenience lies in favor of grant of injunction, and in the event such injunction is not granted, the appellant may suffer irreparable and irreversible injury. Full stop. Accordingly, can 1 of 2024 is allowed on contest, thereby granting injunction restraining the respondent and or his men and agents from selling, transferring, alienating, alienating and or encumbering the subject property covered by the disputed will, and or creating any third party interest, and or changing the nature and character of the said property till disposal of the appeal. Full stop. Next para. In view of appearance of the respondent through his learned advocate, service of, there is only one respondent.
One.
The service of notice of appeal is dispensed with. Full stop. Next para. The trial court records along with the will be brought by special messenger at the cost of the appellant, to be deposited within a week from date. Full stop. The will, when it arrives before this court, shall be kept in safe custody by the learned registrar general of this court, subject to any direction of the court for production of the same at the time of hearing of the appeal. So next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who is of liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
One indulgence, my lord, that will not create the delivery of the probate. That has not to be.
It is made clear that we have not passed any restraint order on the delivery of on the grant of probate in favor of the respondent in terms of the impugned judgment and decree.
I'm appealing for the appellant, my lord. It's my section 5 application.
It is appealing for the first time, or do you have
yes, my lord. Direction of service may be given.
Good. What is the delay?
My lord, 124 days, my lord.
The appellant shall serve copies of the what other application? Is there any other application also?
No.
The appellant shall serve a copy shall serve copies of the present application on the respondents, indicating that the application shall be listed for hearing on February 10, 2025, when an affidavit of service shall be filed by the appellant.
Item number 14, my lord, I am appearing on behalf of the appellant on the
This
last.
is again appearing under the wrong heading. Sorry, let it appear tomorrow on Monday. Let the matter be listed under the appropriate heading on January 27, 2025.
I'm
We
grateful.
are sorry, this is our fault.
I'm grateful. I'm grateful.
Item number 50, I'm for the appellant lordship.
Yes,
Lordship, as per the last
you're for the respondent, right?
as per the last direction in the proposal made by your lordship that to file undertaking.
Oh, that.
Yes, lordship.
So you're
Uh,
you are ready. You're considering.
Yes, lordship, I have to say something. My client is not ready to file the undertaking.
Ah.
My lord can pass necessary orders. Anyways, the execution proceeding will be held in June.
Let us just check up. We'll record that they're not agreeable and we'll refuse stay. We proceed with the execution case.
Your lordship, then
We'll record that. We'll dismiss the step.
Your lordship.
By an order dated January 21, 2025, comma, we had heard at length Can 2 of 2024 and had arrived at the conclusion, comma, on the reasons as given therein, comma, that we are not inclined to grant the prayer for stay since no prima facie case has been made out for such grant. Push up next para. However, comma, at that juncture, comma, learned counsel for the appellant had submitted on instruction that the appellant is agreeable to hand over vacant and peaceful possession of the premises to the respondent in 6 months' time. Push up next para. Today, when the matter is called on for hearing, comma, learned counsel for the appellant submits that the appellant has resigned from such position subsequently. Pushed up as such, comma, the question of direction being given to file undertaking or granting time for 6 months to the appellant does not arise any further. Post up next para. In view of the reasons attributed in the order dated January 21, 2025, comma, which we do not want to unnecessarily repeat, comma, Can 2 of 2024 is dismissed on contest without any orders to cost. Full stop. The appellant shall be the respondent number 1 decree holder is at liberty to proceed with the connected execution case, and the executing court shall ensure that the same reaches its logical culmination at the earliest. We can direct you to put in special messenger cost and all.
Lordship.
Your client will do nothing, probably.
Sure.
But special messenger cost, respondent number 1, is there any other respondent? Other respondents necessary parties?
They are the sons.
No.
Performer.
Acha. In view of appearance of the respondent number 1, comma, the plaintiff in the court below and the decree holder, comma, through his learned advocate, comma, service of notice of the appeal is dispensed with on the respondent number 1, full stop. Since there is no relief claimed against the pro forma respondent, comma, service of notice of appeal on the pro forma respondents is also dispensed with. Full stop. The appeal be treated to be ready as regards service. Full stop. Upon the trial court records arriving before this court, comma, examined and found to be complete, comma, a notice of arrival of the said records shall be served on the learned advocate from the appellants. Full stop. Upon such service, comma, the appellants shall prepare and file the requisite number of paper books within 8 weeks from such date of service of notice. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. We are not directing special messenger cost because you will have to put it from your pocket then.
I'm grateful.
Your Lordship, I'm praying for a day's accommodation in
If
this
you
matter.
move the matter.
Your Lordship,
This is item number 16.
16. Your Lordship, the senior appearing in
No.
this
On the last occasion, we had adjourned the matter.
matter. Your Lordship, the
Mr.
senior.
Dhirodatta Chaudhary, where is he? He was to be here.
Your
This is
Lordship-
item 16.
Yes, Your Lordship.
Abdul Shovan.
Your Lordship, my
When Mr. Dhirodatta Chaudhary appeared, we distinctly remember we told him that no adjournment. On the next day, if the senior is not there, you have to move there.
Your Lordship,
Where is he?
he is not in the court, Your Lordship. Your Lordship, the senior mentioned the matter before the court was rising yesterday. Due to his personal difficulty, he
Who is the
couldn't come.
senior?
Safiullah Mondol. He mentioned the matter
But he
yesterday.
did not mention that this order was there.
Your Lordship,
Anyway,
my
as an adjournment is sought for the appellants, full stop, as a last chance to the appellants to argue the matter. The same is postponed till January 27, 2025. Full stop. It is, however, made clear that repeated adjournments are being taken by the appellants. Full stop. In the event the appellants do not appear or seek adjournment on the next date when the same is called on for hearing, ex parte orders may be passed in the absence of the appellant.
Grateful.
Last mention for
that I appear for the appellant, that I must indicate there is a condonation of delay application, delay for 294 days. Well, the first item is the parent order, and the next matter is the last order which has been extended. This is, my lord, the appeal is against an order of injunction in a contract of personal employment, my lord. Termination has been restrained, though, my lord, the terms of the employment provides that.
Section 5 you have to serve because the parent order.
Section 5 is there.
So this
We have
appearing for
served,
the
my
first.
lord, we have
You're
served
appearing.
them. We have served them. We have served them.
So what the section 5 ta kothay? It. Okay. Na.
294 days delay.
What is the reason, Mr. Chaudhary?
My lord, the reason is, my lord, we had thought, my lord, we have filed our opposition over there. My lord, mechanically it is getting extended and we are being forced between, my lord, last 6 months to 8 months, my lord, mechanically getting extended and we are not getting an opportunity, my lord. We have preferred an appeal from the parent order and also from the last order extending it, my lord. Ad interim order, it's continuing and I have to unnecessarily, my lord, go on, my lord, paying the salary.
Termination has been restrained. I mean,
Well, in fact, the impugned letter was that your role is no longer required. Please meet us on this date when we will again revisit. If there is any other role suitable for you, you will be considered. Otherwise, we will have to terminate.
any reason was attributed. I mean,
Against that, my lord, the order says that there is a threat of termination, which is against the contract. Therefore, we are.
Yes, what do you say to the section 5? We can dispose of the appeal itself against you.
Regarding this section 5, my lord, it's a delay of 294 days. They could have preferred an appeal, but instead of preferring appeal, they filed an application under Order 7, Rule 10, my lord, which was part heard. And in the meantime, the judge who was officiating court number 7 has been transferred. Now the court is lying vacant. My lord, they have submitted their submission, my lord. We are to start. But
I am not on Order 7, Rule 10. I am on the parent order.
The injunction application is still to be disposed of.
Yes.
The initial order was ex parte.
Initial order was ex parte.
And that has been
But
continued.
that has to be, the statute says that it has to be decided within 30 days.
Well, it was, instead of filing their objection, my lord, against the injunction, they preferred an application under Order 7.
Objection also
Order
filed.
7 Rule 10 is not.
We have also filed objection.
But they were pursuing with that application under Order 7 Rule 10, that the order sheet says so. And they have concluded their submission. We are to begin. At this stage, the judge was transferred.
No, we are condoning that. Can 1 of 2025 is an application for condonation of delay of about 294 days in preferring the appeal. Push up next para. The concerned appeal, bearing FMET number 21 of 2025 has been preferred against grant of an ex parte ad interim injunction in favor of the respondents. Respondent number 1. Full stop. Next para. On the other hand, FMET 22 of 2025 arises out of an order extending the said ad interim order. Full stop. Next para. Learned senior counsel appearing for the appellant submits in support of the condonation application that the application that there was no necessity felt by the appellant initially to prefer an appeal comma, since the appellant filed its written objection in the court below to the main injunction application and was confident that the injunction application would be disposed of within the statutory timeline of 30 days. Full stop. However, comma, till date, the same having not been disposed of, comma, the present appeal was necessitated. Full stop. Next para. Learned counsel for the respondent number plaintiff stroke respondent number 1 seriously opposes the application for condonation of delay. Full stop. It is submitted that the appellant, comma, instead of expediting the hearing of the injunction application, comma, delayed the same by pursuing an independent application under Order 7, Rule 10 of the Code of Civil Procedure. Full stop. Next para. Hence, comma, there is no justification for the delay in preferring the appeal. Full stop. Upon hearing learned counsel for the parties, comma, we find that now we find absolute candor, CANDOUR, on the part of the appellant, inasmuch as the appellant has not attempted to attribute any frivolous reason to the delay. Full stop. There is substance in the submission of the appellant that the appellant did not feel aggrieved at the inception when the impugned order of ex parte ad interim injunction was passed, since there was confidence in the mind of the appellant that the main injunction application would be disposed of at an early date, comma, particularly since written objection was filed to the injunction application. Push up next para. The limitation in such case, comma, has to be seen as somewhat fluid, comma, depending on the perception of being aggrieved by the appellant. Full stop. It may be said, comma, on a wider interpretation of the expression double inverted aggrieved, comma, that the present appellant felt aggrieved by the impugned order of ad interim injunction only when the main injunction application was not disposed of within the statutory timeline of 30 days and was prolonged over an inordinate period of time. Full stop. Next para. Keeping in view the explanation in the above context, comma, we are of the opinion that sufficient reasons have been given for occasioning the delay in preferring the appeal. Full stop. Insofar as the appellant pursuing an application under Order 7, Rule 10 of the Code of Civil Procedure is concerned, comma, the same is independent of the injunction application and the two cannot be mixed up. Full stop. Next para. Hence, comma, we are inclined to condone the delay in preferring the appeal. Full stop. However, comma, since we have not invited affidavits, comma, it is deemed that none of the allegations made in the present application are admitted by the respondents. Full stop. Next para. In view of the above, comma, can 1 of 2025 is allowed, comma, thereby condoning the delay in preferring FMET number 21 of 2025. Full stop. Now we take up the appeal for admission hearing.
Yes, my lord.
We are also admitting because sufficient grounds have been made. But then we'll have to stay. If you agree, we can dispose of the appeal itself, if not today, then on Monday. Or we can, hear you on the stay. And if you grant stay, then nothing remains in the.
My lord, what I suggest, my lord,
Because personal contract, in the nature of termination of personal contract, you know very well specific real fact bars.
there is a bar, but my lord, there is one thing, my lord, the procedure followed by the bank is not justified. My lord, he should be given a 3 months notice, which was not given. And straight away a notice of redundancy was given.
Achha, we'll do this.
My lord, I am conceding, my lord, from today I will give further 3 months salary and I will terminate. I am conceding to that. I
My
could
lord,
not,
let
I am
me-
conceding to that.
What I suggest, my lord, since
If this-
the court number 7 is vacant, my lord, there is a judge in charge. My lord, let it be sent back with a time.
No, my lord,
within a month he will hear and dispose.
Lord, I am continued, I am forced to pay salary though I don't want him.
That is that. See,
We'll say we'll admit the appeal and we'll put it for hearing on Monday. On Monday. In view of an arguable question having been raised in the appeal, comma, particularly since an order of injunction has been granted in respect of termination of a personal contract, comma, which apparently is barred under the Specific Relief Act 1963, comma, the appeal is required to be heard on the above ground and the other grounds taken in the memorandum of appeal. Full stop. Accordingly, we hereby admit the appeal. Full stop. Since the documents annexed to the memorandum of appeal and the application are sufficient to dispose of the appeal, no, all documents are not there, probably.
Milord, in the next matter, which is the last order extending it, all the documents
are there, very comma, and যেখানে ছাড়লাম ওখানে comma, and as the two appeals are interlinked, comma, one arising out of the initial identity order and the other from the subsequent extension of the same, comma, both the appeals can be heard analogously without directing formal preparation of paper books, comma, on the materials already on record. Full stop. Accordingly, we fix the appeal for hearing. Accordingly, we direct that the appeal shall be listed for hearing on January 27. We accordingly direct that both the appeals shall be listed for hearing analogously on January 27, 2020.
My lord, can I pay for some other day, my lord? But kindly fix it on 30th or 31st.
Why? Will
My
not
lord, on 27, my lord, I am
28th, 29th,
29. Let it be
29th.
29.
তাহলে ওটা ডেট রিটার্ন ডেটটা 29th করে দিন।
29
Full stop. আচ্ছা, যেখানে বললাম both the appeals shall be listed for hearing along with the connected stay applications, because if you
Deeply
grant stay, Mr. Chaudhary, nothing remains.
No, no. The Lordship is hearing the appeal, Milord. I can't ask more than that. Deeply obliged.
Thank you. হ্যাঁ, বোর্ড ওয়েটিংটা বোর্ডে শো করিয়ে একবার শো করিয়ে তারপর 19 এ চলে যান, একবার দেখিয়ে দিন বোর্ডে। এই অ্যাকশন, ওকে মেঘনাথ। Yes.
My lord, just
9. Yes, what is
between item number 17 and 18, the affidavits of service are here. So
একটা লাইন অ্যাড করে দিতে হবে আগেরটা, affidavits of service filed to be kept on affidavits আগেরটা। Yes, what is this matter? What is the defect? Cured?
Defect is cured.
Defect is cured. What was
You had a short list of dates.
short list of dates? Yes. What is the matter about?
Well, kindly come at base.
We have 1 minute left. Please come back after recess. We'll continue. This will be the first matter after recess.
Standard charter.
এটার আগেরটা দিচ্ছেন আবার কি করছেন? এই দুটো আগেরটা দিয়েছেন। Yes. List of dates.
My lord, 16th November 2012, petitioner purchased 14 shatak of land, got the same mutated in his name. My lord. 27th August 2014, respondent as plaintiff, my lord, filed a suit for partition, being suit number 175 of 2014. My lord, next page, my lord. My lord, 19th January 2024, petitioner filed an application under Order 7, Rule 2 of the 11 of the Civil Procedure Code for rejection of plaint. My lord, 12th August 2024, plaint was rejected. The respondent number as plaintiff, my lord, filed a tried to sue for file an appeal, my lord. Next page, my 9th December and 19th December. Honorable Justice Shobhasaj Bhattacharya, Honorable Justice Suprati Bhattacharya are pleased to hear the appeal dismissed as non-maintainable on the ground lack of pecuniary jurisdiction and gave liberty to prefer the appeal before the appropriate case. Subsequently, the above matter again appeared in the list. Honorable Justice Bhattacharya and Honorable Justice Uday Kumar were pleased to hear the matter and again decided that the appeal is lack of pecuniary jurisdiction and gave liberty to prefer appeal before the appropriate court. My lord, petitioner started boundary wall, my lord, around the land, my lord. Then, my lord, on 25th of December 2024, the respondent being the filed a new suit for partition. Again, on the same cause of action, my lord, the averment in title suit number 175, my lord, 2014, and the averment present same, my lord. Suppressing all the facts, my lord, file a new suit for partition bearing title suit number 47/2024 on the same cause of action and issues and same schedule of land, obtained an order of status quo, my lord. And my boundary wall is
Partition suit, partition cause of action, isn't it continuing cause of action? Can they not file? Have they disclosed anything subsequent?
no, well, subsequent, no, nothing.
Let us see the
I
two
suppress
plaints.
everything suppress.
Let us see the two plaints.
My lord, kindly come to the plaint.
Yes.
My lord. My lord, I have annexed and the valuation is given. Their valuation is given 1,50,000. Here valuation given 3 lakhs. But kindly come to the, I have annexed, my lord. I have annexed with the memo of appeal, my lord, the current, my lord.
Let us see the two plaints.
My lord. And I have annexed, my lord, the early, second one is, my lord, at page, my lord. এটাই তো হ্যাঁ my lord, page 53, my lord. Page 53 of
the first one.
First one, my lord. Only হুবহু my lord, paragraph wise, my lord.
Let us see the cause of action.
Page 53 onwards, my lord. And the earlier one.
The previous suit is still pending.
No, my lord. They have not. They did not prefer any appeal.
Plaint was rejected. So therefore,
they did not prefer any appeal as per your lordship's order.
Why was the plaint rejected?
My lord, that order I have annexed one.
What was the reason for rejection of the plaint?
Son of plaint যেটা আরে কত পাতা আছে হ্যাঁ plaint rejection of plaint কি বাবা 12/8 না না এটা তো আমাদের অ্যাপ্লিকেশন আরে অ্যাপ্লিকেশন তার আগের পাতা মানে পেজ 69 মানে
Section 80 was a bad ground. State is not a necessary party. No relief. It was rejected on the ground of Section 80 of CPC.
And my lord's order, well, kindly see my lord's order. Order
Order regarding what? What did you do? We held that the appeal does not lie before this court, only that.
and gave liberty to file before the appropriate.
That they have not. But here they have not made the state a party now.
No, my lord. Only that thing.
But they're entitled to maintain a suit because the cause of action date they have given differently.
But the only
previous suit was dismissed on the ground, the plaintiff was rejected on the ground Section 80 not complied with. Section 80 because state was a party.
only one date is changed, my lord. For the purpose of cause of action, nothing else.
Partition
And
is a-
suppression, my lord, suppression, everything, my lord. My lord, I have everything. I have all the documents,
Suppression
my lord.
only vitiates if it is German. If even if the previous suit was the plaintiff was rejected, first of all, plaintiff rejection does not debar filing of a fresh suit on the same cause of action. Order 20, order 11, order 7, rule 11, 12, 13 are very clear on this.
But they have suppressed, my lord.
If it does not prevent them from filing a fresh suit by even if suppression, then why should it? Ad interim injunction has been granted.
My lord,
Expertise.
status quo, my lord. My boundary wall is stopped, my lord.
Expertise.
What? My lord, kindly see the boundary wall, my lord. Once again, my lord.
No, we in any event, even if we admit the appeal, we won't grant a stay of injunction. That would be allowing the appeal at the outset. Injunction orders are not stayed.
Status quo.
Status quo means injunction. You have been restrained.
My lord. Boundary wall টা কোথায় গেল? আরে boundary wall দিয়ে ভাই ছবিটা।
What other ground do you have apart from suppression?
Oh, nothing, no more, my lord. My lord, kindly see the page 67, my lord.
Partition is a continuing cause.
My lord, page 67, kindly see, my lord.
67, yes.
'67 and 68.
You already partially
Partially, my lord. Not complete. One lakhs of materials, my lord, are lying there, my lord.
We'll admit and serve them notice of serve copies of memo as well as the application.
Well, in the meantime, my lord, stay, my lord.
No stay of injunction. No. Stay would tantamount to allowing the appeal before hearing them. Injunction orders we never stay. The learned counsel for the appellant argues that the suit in connection with which the impugned ex parte ad interim status quo order has been passed has been filed upon suppression of material facts. Full stop, next para. It is contended that a previous suit bearing title suit number 175 of 2014 had been filed for identical reliefs on the self-same pleadings, full stop. The plaint of the said suit was rejected on the ground of non-compliance of Section 80 of the Code of Civil Procedure, full stop. A challenge was preferred before this court where it was held by the division bench of this court that the appeal is not maintainable here due to pecuniary jurisdiction, and liberty was given to the appellant, that is the present respondents, to approach the appropriate court having determination. Full stop. Instead of doing so, the present fresh suit has been filed on the self-same cause of action. Full stop. In the present suit, the suit valuation has been increased to rupees 3 lakh to bypass the issue of pecuniary jurisdiction on which the previous appeal was turned down. Full stop. Next para. Thus, it is argued that due to such suppression of material facts, the impugned order of ex parte injunction is bad in law. Full stop. Next para. Moreover, comma, it is argued that after the plaintiff stroke appellant substantially constructed his boundary wall, comma, the same has been stopped midway by virtue of the status quo order. Full stop. Next para. The above grounds raise serious issues which are to be considered in the final hearing of the appeal, and the appeal is required to be heard on the said questions as well as the other grounds taken in the memorandum of appeal. Full stop. Accordingly, the appeal is admitted. Full stop. Next para. The application for stay is taken up for hearing. Full stop. However, comma, if at this juncture an order of stay of operation of the impugned injunction or impugned status quo order is passed, comma, it would tantamount to allowing the appeal, comma, since staying the operation of a prohibitory order opens up an opportunity for the appellant to complete the construction which has specifically been restrained by the impugned order. Full stop. Such order cannot be passed at this juncture. Full stop. However, comma, in view of the appeal and the application involving similar issues, comma, let Can 1 of 2025 be listed along with the hearing of the appeal on in the monthly list of March 2025. Full stop. Next para. In view of the relevant papers being available on record, comma, the trial court records need not be called for. Full stop. The appellant shall serve copies of the application as well as the memorandum of appeal, which shall be treated to be notice of the appeal as well. Full stop. Next para. It is made clear that the merits of the matter stay application have not been gone into at this stage. Appeal and application will appear together in the monthly summary. Ensure that they are served. Memo as well as application.
Number 20.
Today there is some opportunity. Yes. Paper book. এটা 2 ভলিউম 2 এটা একটু সাইডে রাখুন এটা ওনার ভলিউম 2 টা সাইডে রাখুন যখন লাগবে তো so let us see the remand order.
My lord, as my lord stated earlier, my lord, two orders.
Your ground is that the trial court has opened up all issues contrary to the remand order.
And exactly, my lord, what is specified in the remand order, my lord, that issue has not been dealt with at all.
Achha, that has not. Let us see the remand order. Should we see the remand order first and then come to the input judgment or whatever you like?
Yes. My lord, that way, my lord,
That
your
would be
lordship will
easier.
take, my lord.
So let us come to page 154.
Yes, my lord. My lord, this remand order, my lord, arises out of an appeal, my lord, filed by, my lord, the plaintiffs, my lord, in the previous round of litigation, my lord. In the suit was initially dismissed. After that, my lord,
Suit was a partition.
No. Consequential, my lord, that is also, my lord, one of my case, my lord.
What is the declaration? The title?
My lord, declaration.
Joint title.
Jointly lawful owners to the extent of 1/5 share. And will declare further declaration that the defendants number 1 and 2 have got no manner of right to those shares, securities and absolute owners thereof on the strength of the said impugned extension.
An injunction.
In an injunction. Therefore, my lord, in the other case, my lord, where my lord, lordship, my lord, favored us with a order, my lord, in that matter, my lord, the difference is, my lord, I was in possession of that particular, my lord, even if my lord, I did not seek for a partition, my lord, that was on the strength of that, my lord, that I am happy with my possession, my lord, I am, my lord, willing to continue the status. In this case, my lord, the case may be slightly different. Whether, my lord, consequential relief, my lord, in this case, my lord, would be necessary, my lord.
What consequential? Recovery of possession?
Not recovery of possession, my lord. The shares, that is, the dispute is with regard to the shares. Shares and securities left by the predecessor in interest.
Partition is other relief, so 34 proviso does not come in.
Well,
the thought for declaration of their content with declaration of their joint title and
interest over the shares. And so far as the money, my lord, that comes out of the shares,
Yes, that they're interested in, and this injunction and position of each is position of all.
My lord, my lord. Well, and anyway, my lord, I cannot, my lord, what the remand order has specified, my lord, I cannot traverse beyond that, my lord. Beyond that. My lord, page 154, my lord, I'm starting off. My lord. The first appeal is at the instance of the plaintiff in a suit for declaration and permanent injunction and is directed against the judgment and decree dated 31st of May 2004, passed by the learned judge, third bench civil court in Calcutta, entitled suit number such and such, thereby dismissing the said suit. The plaintiffs filed the aforesaid suit for declaration that they are jointly lawful owners to the extent of 5/6 share, having 1/6 undivided share each of the total shares and securities left by one Sharup Bikash Shet, the predecessor in interest of the defendants, my lord, as well as of the plaintiffs, my lord, and for further declaration that the defendants have no right to have those shares and securities as absolute owners thereof, on the strength of the extended succession certificate granted in Act 39 case number such and such, which is an extension arising out of Act 39 case number such and such of 1975. The plaintiff further prayed for a permanent injunction restraining the defendant number 1 and 2, their main agents, from giving effect to or further effect to or from acting upon the extended succession certificate number such and such of 1995. The case made out by the plaintiff's appellants may be summarized thus. One Sushil Kumar Shet, the undisputed predecessor in interest of the parties, died on 20th September 1964, leaving one son, two daughters through his predeceased first wife, the second wife, and one son and one daughter through the second wife. The only son through the first wife, namely Sharup Bikash Shet, subsequently died on 22nd March 1971, leaving his widow and one daughter, who are the defendants. The plaintiffs are all the other heirs of Sushil Kumar Shet, my lord, other than his eldest son, that is Sharup Bikash Shet, and the widow and the daughter of Sharup Bikash Shet are the defendants in the suit. On the death of Sushil Kumar Shet, Sharup Bikash Shet, being the eldest son in the family through his first wife, was the Korta, and accordingly he took over charge of all the assets left by Sushil Kumar Shet and used to look after, manage, control, and supervise all the assets of the estate of Sushil Kumar Shet in his capacity as the Korta of Hindu undivided joint family. On the death of Sushil Kumar Shet, an application was filed for grant of succession certificate for the purpose of receiving the debts and securities payable to the estate of Sushil Kumar Shet, and the learned court, with the consent of the other heirs, granted succession certificate in favor of Sharup Bikash Shet to receive those debts and securities. Sharup Bikash Shet got those shares and securities of different companies standing in the name of Sushil Kumar Shet and subsequently transferred those shares in his personal name, with the understanding that Sharup Bikash Shet would hold those shares and securities and other shares left by Sushil Kumar Shet not for his personal benefit but for the benefit of others, including himself. But I contradict this case. Having obtained succession certificate in Act 39 case number 212 of 1966, Sharup Bikash Shet reinvested the entire amount so realized by him from different companies, bank accounts, Life Insurance Corporation of India in his own name, and also used to collect monthly rental from different tenants from the estate of Sushil Kumar Shet, and out of such total accumulation made various investment in different money growing scheme of different companies in his personal name for the benefit of himself and also for the benefit of other heirs of Sushil Kumar Shet. Subsequently, Sharup Bikash Shet died in 1971, leaving the defendants as his sole legal heirs and representatives, and after such death, the defendant number 1, being his widow, duly filed an application under section 372 of the Indian Succession Act for grant of succession certificate for receiving the debts and securities payable to Sharup Bikash Shet in her favor, which was registered as Act 39 case number 227 of 1975. And in paragraph 4 of the said application, she categorically stated that deceased left other near relations, namely his stepmother, stepbrother, and 2 sisters and 1 stepsister, being the daughter of late Sushil Kumar Shet through his second wife. Prior to filing of the said application for grant of such succession certificate, the defendant number 1 wrote a letter to the income tax authorities informing that her husband, Sharup Bikash Shet, had only 1/6 share of the total dividend income out of the share and securities so left by him, and accordingly the appellate Assistant Commissioner of Income Tax Range AA, Calcutta, was pleased to pass an order holding inter alia that her husband had only 1/6 share in the dividend income. Well, now, my lord, comes the important question. It further appears from the annexure appended to the application for succession certificate filed by the defendant number 1, which is, my lord, the extended succession certificate in 1996. The total debts and securities were divided into 5 categories. So far as item number A and B were concerned, Those were the shares and securities of various companies inherited from Sushil Kumar Shet, and so far as item number C, D, E and were concerned, those were the money lying in the personal name of Shaurubh Vikas Shet in two different life insurance policies, and money lying with Excel India Limited in his personal name. It further appears that the defendant number 1 and 2 claimed only 1/6 share in item number A and B. The CDE, my lord, there's no dispute with CDE. Upon receipt of such notice of succession case number being number 39 of 227 of 1975, the plaintiffs entered appearance therein and filed their written objection and categorically stated that the said application for succession certificate was not maintainable in its form, and the deceased Shaurubh Vikas Shet, being the eldest member of the family of Sushil Kumar Shet, duly invested huge amount out of the asset left by Sushil Kumar Shet, and all the shares and securities standing in his name were so invested for the benefit of all the heirs of Sushil Kumar Shet. After filing of such written objection in the said succession certificate, case number Act 39, case number such and such, the defendant number 1 found it difficult to succeed in the said case, and in such a situation filed an application definitely stating therein that she was inclined to obtain succession certificate in respect of only item CDE, and accordingly the court granted such succession certificate in respect of those items. In the month of February 1996, the plaintiffs for the first time came to learn from searching of the court that court record that the defendant number 1 subsequently had obtained an extended succession certificate in respect of the shares and securities which were mentioned in the schedule of shares and securities on the basis of further application under section 376 of the Indian Succession Act, which was registered as Act 39, case number 234 1995 extension, by praying grant of extended succession certificate of all the shares and securities for which she had earlier abandoned her claim. And the court granted such succession certificate without giving any notice to the plaintiffs. The plaintiffs therefore filed an application for revocation of the said grant of extended succession certificate before the court below, but the learned court did not allow such application. Since, my lord, the issue of title was looked into, my lord, the court said, my lord, in succession certificate, I cannot go into the title. The aforesaid action on part of the defendant number 1 casts a cloud upon the 5/6 share of the plaintiffs in the assets left by Sushil Kumar Shet, and as such, the said suit was filed. The aforesaid suit was contested by the defendants by filing written statement, thereby denying the material allegation made in the plaint, and the defense taken by the defendant may be summarized thus. Shaurubh Vikas Shet was never the Kotta of the undivided family as alleged by the plaintiff. Shaurubh Vikas Shet during his lifetime of Sushil Kumar Shet had been living in a separate mess because his stepmother formed a separate unit along with other children, and Shaurubh Vikas Shet at the time left under the was left under the care of the relatives till marriage. All the shares and securities standing in his name had been accumulated in his name from his personal earnings. Shaurubh Vikas Shet was a partner of Messrs. Sushil Kumar Shet and Brothers, and he used to receive his remuneration therefrom and invested his savings to purchase share and securities. The defendant number 1, being an innocent lady, put her signature on the application in succession certificate in case number such and such without understanding the contents of the same. Shaurubh Vikas Shet got 1/6 share on the death of Sushil Kumar Shet, and after obtaining succession certificate, paid the 5/6 share of asset of his father realized by him on the strength of succession certificate to the plaintiffs, and got receipt in presence of Anil Kumar Shet, his uncle. But subsequently, the plaintiff number 1 broke open the almirah of the defendant number 1 and had stolen away the said receipt. At the time of hearing the suit, the plaintiff number 2 alone gave evidence on behalf of the plaintiffs, while the defendant number 1 deposed on behalf of the defendants for the purpose of refuting the claim of the plaintiffs. As indicated earlier, the learned trial judge, by judgment and decree impugned herein, had dismissed the said suit, holding that the plaintiffs failed to prove that shares standing in the name of Shaurubh Vikas Shet were really purchased from the money received from the estate of Sushil, by accepting the defendant's case that on the death of Sushil Kumar Shet, his 5/6 share of the money realized by Shaurubh Vikas Shet was given to the plaintiff on taking receipt, but subsequently plaintiff number 2 has stolen such receipt. Being dissatisfied, the plaintiff, Mr. Dasgupta, learned senior advocate appearing on behalf of the appellants for the first time, contended that there is no dispute that on the death of Sushil Kumar Shet, the succession certificate was granted in favor of Shaurubh Vikas Shet. the predecessor interest of the defendants. Mr. Dasgupta contends that there is no dispute that huge amount of shares and securities lying in the name of Sushil Kumar Shet were handed by Swarup Vikas Shet on the basis of succession certificate, and as such it is the duty of the defendants to show that fifth, sixth share arising out of those shares and securities were paid to the plaintiffs. Mr. Dasgupta contends that in this case, no prudent person will believe the defense of the defendant number 1 that such receipt was stolen from an almirah, although not a single complaint had ever been lodged before the police in this connection. Mr. Dasgupta thus submits that in absence of any evidence showing that either Swarup or the defendants paid the 5/6 share to the plaintiffs out of the total assets left by Sushil Kumar Shet, the learned trial judge ought to have decreed the suit. The aforesaid contention of Mr. Dasgupta was seriously disputed by Mr. Banerjee, learned senior advocate appearing on behalf of the defendant number 1 and 2. Mr. Banerjee practically supported the judgment and decree passed by the learned trial judge and contended that the defendant number 1, being an half-educated lady, was not aware of the contents of the application of the succession certificate, where so far as the share and securities mentioned therein are concerned, the defendants were shown to have 1/6 share. He therefore prays for dismissal of the appeal. After hearing the learned counsel for the parties, and after going through the materials on record, we find that on the death of Sushil Kumar Shet, all his properties devolved upon his 6 heirs, including predecessor interest of the defendants, each having 1/6 share. Subsequently, Swarup Vikas Shet, the eldest son, and Shormishta, one of the daughters, through his first wife, died, and their heirs had been brought on record. There is also no dispute that on the death of Sushil Kumar Shet, it was Swarup Vikas Shet, the predecessor interest of the defendants, who got the succession certificate and was authorized to realize all the shares and securities and debts payable to Sushil Kumar Shet. Therefore, as the holder of succession certificate, it was the duty of the heirs of Swarup Vikas Shet to show that he had discharged such duty by handing over the actual amount received by him to the heirs of Sushil according to their respective shares. In this case, specific defense by the taken by the defendants was that the 5/6 share was given to the plaintiff on the basis of the receipt granted by them in presence of Anil Kumar Shet, advocate, but subsequently the plaintiff number 2 had stolen the said receipt from the almirah of the defendant number 1 after the death of her husband. In cross-examination, she had, however, admitted that she could not remember the date of the incident and that no such incident was ever reported to the police. It is needless to mention that plaintiff number 2 has specifically denied such allegation in his evidence, but in spite of such denial, the learned trial judge proceeded as if Shamol, the plaintiff number 2, had not denied such event. Therefore, the findings of the learned trial judge that 5/6 share of the plaintiff realized by Swarup was paid after granting a receipt is perverse finding of fact, and no reasonable man would come to such a conclusion from the materials on record. The fact that such share was not given to the plaintiffs would appear also from the conduct of the defendant number 1. It appears that after the death of her husband, she applied for fresh succession certificate for receiving the debts and securities standing in his name. And in that application, the Schedule A and B properties were the shares and securities which are subject matter of the present suit. In the said application, she specifically claimed 1/6 share in respect of A and B schedule, and so far as the C, D, and E are concerned, she claimed to be the full owner with her daughter in view of the objection raised by the plaintiffs. She abandoned her claim in the shares and securities mentioned in Schedule A and B, and she was satisfied with the items mentioned in Schedule C, D, and E. Subsequently, long 20 years thereafter, in the year of 1995, she prayed for extension of the certificate by claiming absolute right over those self-same securities and shares over which she abandoned her claim earlier, and such certificate was granted in her favor without giving notice to the plaintiffs. It is now a settled law that mere grant of succession certificate in favor of a co-sharer does not vest the co-sharers with the title of the property, and it is duty of the certificate holder to distribute the assets to the heirs in accordance with the share. Therefore, my lord, so far as A and B are concerned, my lord, the cases arise in my lord, which is, my lord, subject matter of the extended certificate, succession certificate. But I'll, my lord, show from the, my lord, the schedules of both the plaintiff and the extended succession certificate. Once we hold that the plaintiff did not receive their 5/6 share in the property, it is duty of the defendants, being the heirs of Swarup Vikas Shet, to account for the assets dealt with him by virtue of succession certificate granted in his favor on the death of Sushil. Although the learned advocate for the parties argued considerably on the question whether original shares held by Sushil were really transferred in the name of Swarup, we find, my lord, this part is important, from the record, the sufficient evidence has not been adduced at the time of hearing as to the exact number of share and security held either in the name of Sushil or Swarup. And the learned trial judge did not come to a definite conclusion whether those shares were really transferred in the name of Swarup Bikash or are still appearing in the name of Sushil. Even the actual amount of money realized by Swarup by virtue of succession certificate is not brought to the notice of this court. In such a situation, we hold that the plaintiffs are entitled to the 5/6 share of money already realized by Swarup by virtue of succession certificate granted in his favor, as nothing has been paid to them. In this proceeding,
But the succession certificate also covered CD and D.
The extended succession certificate.
Extended included A and B.
A and B. Original ballot included CD and E. So
But
far
the
as CD
finding of the remand, the appellate court is succession certificate granted in favor. Although the discussion is on CD and E.
CD and E.
I mean
A and B. A and B extend. All along, the extended succession certificate is being put into question.
The present the plaintiffs have brought in the hodgepodge CD and E also.
No. A and B.
CD and E or not the
A and B and few more and A and B and a few more shares.
Still not Mr. Banerjee has clarified that still not claiming anything in CD and E.
No. No. A and B.
Also AB, my lord.
Very understood.
There are
so the extended certificate is the point of flash point rather.
The extended succession certificate consisted of 50 shares in total. From the schedule, 42.
Those are AB.
In the plain, there is 50. 8 more. Where from those 8 come, that
will consider. Yes.
Extended succession certificate AB, restricted to AB, because they have already taken.
Understood, Mr.
And we did not claim CD.
In this proceeding, as the original shares could not be produced by either of the parties, indicating whether those have really been changed in the name of Swarup Bikash or not, we are of the view that the matter should be remanded back to the learned trial judge for the purpose of giving opportunity to the parties to lead further evidence on the aforesaid question. Therefore, the question of remand. Kindly notes, that I am the defendant in the suit. The onus of proving this aspect lies with the plaintiff. Parties are free to summon the concerned companies where those shares are lying for the purpose of showing the strength of the disputed shares as it stands today. If it appears to the court that on the basis of such evidence that the original shares of Sushil are still continuing in his name, and that those are not transferred in the name of Swarup Bikash pursuant to the succession certificate granted in his favor, the court will declare that 5/6 share of the plaintiff and 1/6 of the defendant in those shares only. If it appears that any new share was purchased in the name of Swarup Bikash and the same is not the continuation of the original one standing in the name of Sushil, nor is such a share a bonus share or right issue arising out of the share standing in the name of Sushil, nor was such share even purchased at a premium on the benefit conferred on the share standing in the name of Sushil, the plaintiff will not have right in those shares. Therefore, my lord, is restricted, very much restricted to the shares of my lord Swarup. Very much restricted to that only. However, the plaintiffs will be entitled to get 5/6 share of the amount of money already realized by Swarup Bikash by virtue of succession certificate, and so long such amount is not paid to the plaintiff, the said amount will remain charged over the assets of Swarup. The learned trial judge will grant interest in favor of the plaintiffs over the 5/6 share of Sushil that will be found to be due from the date of realization of the amount by Swarup Bikash till date of actual payment at a rate to be fixed by him after taking into consideration the then bank rate as well as the present existing bank rate of interest on which the parties will be entitled to lead evidence. The parties will also be entitled to lead further evidence on the question as to the amount of money actually realized by Swarup by virtue of the succession certificate granted in his favor. Since the matter is pending from 1997, the learned trial judge is directed to hear out the suit for the purpose of deciding those questions and for passing a decree accordingly on the basis of the evidence already on record and also on the basis of further evidence that will be adduced by the parties on the basis of the order. We make it clear that we have decided the issue as regards of the plaintiff in Sushil's property to the extent of 5/6, and we hold that neither Swarup Vikas Sheth had nor his heirs have paid anything to the plaintiff after realization of the amount, if any, on the basis of succession certificate granted in his favor, and the court will proceed on the basis of such findings. And as such, my lord, the matter was remanded back, my lord, to the very limited issue. After deciding, my lord, 5/6 share in the property of, my lord, the father of the predecessor interest.
Original shares were not produced even after this. Court finds that in the proceeding, as the original shares could not be produced by either of the parties, indicating whether those have been really changed in the name of Swarup, we are of the view that the matter should be remanded back.
Remanded back. And my lord,
now, even after this, original shares were not produced by any of the parties.
Well, in volume B, my lord, a bunch of, my lord, evidence, my lord, exhibits, my lord, those have been, my lord, annexed.
Let us see the impugned judgment then.
Yes. But I'll straight away, my lord, take your lordship to, my lord, 174S.
Yes, decision.
Internal page 19. From the page 20, my lord, let's start.
Yes.
For the sake of convenience and to avoid repetition, all the issues are taken up together. It is admitted that earlier upon hearing, the aforesaid suit was dismissed by the learned court. The plaintiff preferred an appeal and in the Honorable High Court at Calcutta being FA number such and such. Upon contested hearing, the said first appeal was allowed by the Honorable High Court, Calcutta, by his judgment delivered on such as on 9th December 2005, whereby the judgment and decree passed by the learned court was set aside and the instant suit was sent back on remand, directing the learned court to hear the suit for the purpose of deciding some questions which have been realized by the learned court, raised by the learned court on the basis of evidence already on record and also on the basis of further evidence that will be adduced by the parties in terms of the order passed by the learned court. Thereafter, the plaintiffs again examined PW1, Shamul Vikas Sheth, in chief, only my lord PW1, and he has been cross-examined also. And the plaintiffs have produced some more documents. Marks are marked as Exhibit 20 to 31 collectively after objection and Exhibit 32 respectively. But the defendants have not adduced any further evidence but have produced documents marked as Exhibit A. In this case, the plaintiffs in total have examined 4 PWs and produced papers marked as Exhibit 1 to 32 to prove the case. On the other hand, the defendants have exhibit DW1.
20 to 31, Lord, it is in the name of Sushil. Then, my lord, he encashed it, then he purchased it. Those documents were marked exhibit 20 to 31.
But I'll show from the evidence, my lord, whether that question has already come up.
And evidence was given by the plaintiff. He did not cross-examine, declined to cross-examine.
It's stated
No,
that
they stated
it
cross-examined.
has been cross-examined also.
31.
PW1 Shamul.
Let him.
All right.
Let us now analyze the evidence and see if the plaintiffs have been able to prove the case or not. It is admitted that plaintiffs, including one Swarup Vikas Sheth, the predecessor in interest, and the title of the defendant, were and or are heirs, heiress and legal representative of one Sushil Kumar Sheth, who died intestate on 20th of September 1964, leaving behind him the plaintiff and the said predecessor in interest and the title of the defendants, who jointly inherited the estate of the said deceased in equal share. Now, PW1 Shamul Vikas Sheth is deposing for all the plaintiffs. He says that Sushil Kumar Sheth was the father and he died on 20th of September 1964 and he was a businessman. It is admitted. PW1 further said that at the time of his death, his father left his mother, 2 sons and 3 daughters, and the name of his brother is Swarup Vikas Sheth, and he died on 22nd of March 1971. And all the legal heirs of his father were made parties in the case. It is also admitted PW1 further says that he left the LIC policy, money deposited in the banks, share of various companies, etc. It is not denied in cross. PW1 further says that after demise of their father, each of the legal heirs have 1/6 share with respect to the movable assets of the father. It is admitted that the Honorable Court has decided the issue as regards the share of the plaintiff in Sushil's property to the extent of 5/6, and it was further held that neither Swarup Vikas Sheth had nor his heirs have paid anything to the plaintiffs after realization of the amount, if any, on the basis of succession certificate granted in the favor. PW1 says that he was aged 15 years when his father died in 1964. It is not denied. PW1 further says that excepting his older brother Swarup Vikas Sheth, there are no adult members in the family to look after the family. And after demise of their family, demise of their father, Swarup Vikas Sheth used to look after the estate of their father on behalf of all the legal heirs. It is admitted. PW1 categorically says that Swarup was the Korta after demise of their father. It is not denied in cross-examination. I'll show, my lord, whether, my lord, cross-examination at all, my lord, this was denied or not. Yeah, specifically denied, my lord. This question was put. And no suggestion, my lord, was given. PW1 further says that his brother, Swarup Vikas Sheth, filed the succession certificate before the district delegate at Shialda court with respect to the movable assets of the father. It is admitted. He further says that in the schedule of the said application, the details of the movable assets of his father were duly mentioned. It is also admitted. He further says that they were made party as near relations in the said application, and they have filed no objection certificate in granting succession certificate in favor of the said Dada. It is admitted. He further says that on basis of the said succession certificate issued in favor of his brother, etc., it is also it is admitted. PW1 categorically says that he also received money from LIC, and his brother was collecting rent from tenants who were inducted thereby by their father with respect to the residential house, and he used to grant receipt to the tenants by putting his signature. No suggestion denying the same has been put to him. He further says that they filed the said counterfoils of the rent receipt, and the money so collected by his brother was deposited in his own name in the Chartered Bank at NS Bose Road and UBI branch at NS Bose Road. He further says that categorically that the transfer of shares were also done by his brother from the above named bank accounts for his personal account, and he has filed the statement of account of those bank, and the matured value of the LIC policies of his father, which were collected by Swarup Vikas Sheth, was deposited in his personal account of Chartered Bank. He has filed the purchase vouchers of the shares, and those were purchased by Swarup Vikas Sheth, PW1. Swarup Vikas Sheth. PW1 further says that these shares transfer were made on the basis of the money received from the estate of Sushil Kumar Sheth, and Swarup Vikas Sheth never invested any amount for his personal account regarding purchase of and transfer of share of his father. PW1 categorically says that Swarup Vikas Sheth had no substantial source of income. PW1 further says that after demise of Swarup Vikas Sheth, the legal heirs, that is the defendants, claimed succession certificate with respect to the movable assets left by him. It is admitted. PW1 further says that it was numbered as succession certificate case number 227 of 1975, and the same was filed before the learned Chief Judge Civil Court, Calcutta, and they were also made parties in the case. They filed an application along with succession certificate, and they have received notice in that case and filed objection to the case. It is admitted. PW1 further says that in that application there were 5 schedules with respect to the movable assets of Swarup Vikas Sheth, and after they filed objection in the said certificate case, the present defendants waived their claim with respect to A schedule and B schedule of the application. It is admitted. PW1 further says that they have filed the application accordingly, and in that application for succession, the present defendants claim their 1/6 share with respect to the movable assets of Swarup Vikas Sheth. It is admitted. He further categorically says that they have filed an application before the estate duty officer with respect to their 1/6 share, and an order was passed by the estate officer accordingly. It is also admitted. He further says that the defendants preferred an appeal against that order, and an appellate authority confirmed the order passed by the estate officer. It is also admitted that plaintiffs have filed the copy of the said order corroborating the PW1 on this point. PW1 further says that thereafter, the present defendants deposited the stamp duty on the basis of their 1/6 share. It is also admitted. He further says that the defendants were living at 127 Masjid Bari Street, Calcutta 6, where the succession certificate was filed. It is not denied. He further says that the lawyer of the defendants wrote a letter to the income tax authority stating that his clients were entitled to 1/6 share of the assets, and accordingly, he be permitted to file the stamp duty. The plaintiffs have also filed a copy of the said letter. PW1 categorically says that there was one application for extension of succession certificate, which was issued in connection case number 227 of 1975, and the said extension succession certificate, whose number was such and such, and the schedule A and B were included, and they were not made parties in the said extension application, and in that extension certificate, the defendants claimed full shares with respect to schedule A and B of the previous application. These are admitted. PW1 clearly says that the defendants were not entitled to get the full shares of schedule of A and B of the said application, and the entire properties belong to one Sushil Kumar Shet. These were not denied in the cross. The PW1 categorically says that he came to know about the extension certificate in the month of December 1996, and after such application was filed, and after such application was filed, and the plaintiffs also filed the information slips. PW1 says further that that thereafter he filed one miscase before the learned chief judge for cancellation of the extended succession certificate, which was numbered as such and such, and the said miscase was dismissed on the ground that the court had no power to decide the question of title. Thereafter, they filed the case before the court, being title suit number 2369 of 1997, this suit. These are admitted. PW1 categorically says that defendants are not the absolute owners with respect to the movable as mentioned in the application for extended succession certificate. The defendants jointly have 1/6 share with respect to the movable assets as mentioned in the extended succession certificate, and the plaintiffs are not the owners of 5/6 share with respect to the said movables. PW1 further say that in the original succession certificate application, the defendants claims 1/6 share, and the estate duty clearance to that extent was only paid. It is admitted. He clearly says that the total schedule of the shares and certificate as mentioned in the succession certificate case number 212 of 1996 were also the subject matter of the schedule of extended succession certificate application. He also says that besides these shares, the other shares in the name of Swarupbika Shet was obtained from the asset of Sushil Kumar Shet, and after getting the rent from the estate, the plaintiff received those documents from government office and also from the court. He also denies that the defense case in this evidence fully. It is suggested to him that they got their shares in respect of the succession certificate granted in the name of their elder brother, but it is denied by him strongly, and the defense fails to prove it. It is further suggested to him that with the intervention of HON'BLE, their shares were distributed amicably, but it is denied by him strongly, and the defense fails to prove it. It is further suggested to him that he took away the documents relating share certificate, etc., after breaking open of Almira, which was under the possession of the brother illegally, but it is strongly denied by him, and the defense fails to prove it miserably by oral and documentary evidence. It is further suggested to him that the scheduled property was never their joint properties, but it is strongly denied by him, and the defense fails to prove it by oral or documentary evidence. It is further suggested to him that he is deposing falsely, and to grab the opportunity as both he has filed the case falsely, but it is strongly denied by. There is nothing to show that he is deposing falsely. I have gone through the evidence carefully, and I find that there is nothing to show that he is deposing falsely, and nothing transfers from the cross-examination regarding the defense case. But no discussion. He has been cross-examined at great length, but he has stood the test of cross-examination. I find no reason to disbelieve him. PW2, Umarani Shet, widow of late Sushil Kumar Shet, the plaintiff number 1, corroborates the plain case and also finds PW1 on all material points, and also the PW1 on non-material points fully. PW2 also categorically says that her husband died, leaving behind her also the movable assets, namely lump sum of money lying in his name with the Life Insurance Corporation of India, balance in different bank accounts, and also the various shares and securities of different company, and also some immovable property. PW2 categorically says that after death of her husband, his eldest son, namely Sharup Vikas Sheth, being the then eldest son, educated male member of the family, had become the Korta of the said undivided Hindu joint family, and accordingly took over charge of all the assets left by the said Sushil Kumar Sheth, and he used to look after, manage, control, and supervise all the affairs of the estate of late Sushil Kumar Sheth in his capacity as Korta of the undivided Hindu joint family. The PW2 also corroborates the PW1 and plaint case on the point of succession certificate filed by Sharup Vikas Sheth, and also regarding the succession certificate case number such as 227 of 1975, and also succession certificate case number 234 of 1995. PW2 categorically states that defendant number 1, Sharif Sabri, managed to get the said extended succession certificate claiming full share of the shares and securities which has been grown up and purchased from the estate of his deceased husband Sushil Kumar Sheth. PW2 categorically says that actually the defendant number 1 and 2 are jointly 1/6 shareholder of the said shares and securities and the other assets, and the defendants are not absolutely owners of the shares and securities and other assets which have been derived from the estate of the deceased husband. PW2 also says that her husband Sushil Kumar Sheth left a sum of such and such by way of debts and securities, LIC money, LIC, etc. PW2 categorically says that all the shares and assets which had been acquired by the said Sharup Vikas Sheth in his capacity as Korta of undivided Hindu joint family of Sushil Kumar Sheth. She also denies the defense case that during the lifetime of her husband, their family divided into 2 units, and also the personal earnings regarding the shares and securities left by Sharup Vikas Sheth. She categorically says that at that time Sharup Vikas Sheth had no substantial income. I find no reason to disbelieve her. She is an important and competent witness. She supports the plaint case fully on all material points. PW2 supports the plaint case on all material points fully. DW1, Srimati Deepali Rani Shetty deposing for the defendants. DW1 in his defense case, in her evidence, but she does not corroborate the written statement at all. DW1 got married in 1968, that is 4 years after the death of Sushil Kumar Sheth. She says that her husband used to carry partnership business. She admits that her husband used to look after herself, his stepmother, brother, and sister. She also admits regarding succession certificate filed by her husband. She also admits that after obtaining succession certificate from the court, her husband withdrew the dividend, etc. She says that those were the dividend to the legal heirs of her father-in-law, but that has not been proved at all orally or at all by oral or documentary evidence. She admits that at present there is no such document in her custody about the payment of dividend to the other heirs of her deceased father-in-law. She does not know whether she filed the written statement or not. She also admits that prior to the suit, she did not lodge any complaint against the plaintiff number 2 anywhere. She does not know whether her husband used to collect rents of the tenanted premise of her father-in-law. It is also suggested that her husband all along used to reside in a joint mess with her in-laws, etc. But it is denied by her. But the defense fails to prove those. I have gone through the evidence of DW1 carefully, and I find that she cannot be relied upon, and her evidence is uncorroborated one. It does not help the defense case at all. In this case, no oral testimony has been filed by the defendants to show that Sharup Vikas Sheth purchased the shares and securities from his personal fund. Exhibit A does not help the defense at all. All the documents of the plaintiffs are more than 30 years old. Exhibits 1 to 32 support the plaintiff's case very much and corroborate
These
the
are the
plaintiff.
two very important paragraphs. Right?
Yes, madam.
Yes, please continue.
Yes. From those documents and evidence of PWs 1 and 2, it is found that Sharup Vikas Sheth did not purchase those shares, etc. from his income. It is found clearly that he purchased those shares and dividend, etc. from the income of the estate. The evidence of PW1 is genuine and trustworthy, and there is no reason to disbelieve it. Exhibits 6 and 7 support the plaintiff case very much. Exhibits 30 and 31 show that the total purchase by the Swarup Bikash Sheth. From the materials on record, it is found that Swarup Bikash Sheth acted as Karta of the family during his lifetime. It is also found that by suppression of material facts, the defendants fraudulently obtained the extended succession certificate from the court by practicing fraud. It is found that earlier succession certificate contained all the names of all the legal heirs, but the extended succession certificate does not contain the name of all legal heirs, and it is found that the schedule of both are same. It is found that after remand, no oral evidence had been adduced by the defense. My lord, I need not. Their case. As per paragraph 12 of the written statement, it is found that Swarup Bikash Sheth got the share acquired by his own income, but it is not proved by oral or documentary evidence, and no attempt was made to do so. Exhibit 22 to 31 show that it is that the said Swarup Bikash Sheth during his lifetime purchased a good number of new shares and securities in his personal name by making payment out of the income of the estate of late Sushil Kumar Sheth. It is found from the exhibit 22 to 31 that the entire amount of income derived from the estate of Sushil Kumar Sheth was fully credited to the personal bank account of Swarup Bikash Sheth, and subsequently, with the help of that amount, all the shares and securities were purchased in his personal name. It is also found from those documents that by collecting monthly rental and other charges from the different tenants of the estate of Sushil Kumar Sheth, and by collecting other profits from different companies, and with the help of sale proceeds, by selling various shares, and by matured value of LIC policies standing in the name of Sushil Kumar Sheth and said Swarup Bikash Sheth, credited those amount in those bank account in his personal name, and with the help of those income, all new shares and securities of different companies were purchased in his personal name from time to time. The contents of exhibits has not been challenged by the defendants, either by oral or documentary evidence, or by cross-examination of the PW1. From the documents marked as exhibits, it is found that all the shares and securities originally standing in the name of Sushil Kumar Sheth were subsequently transferred in the name of Swarup Bikash Sheth on the strength of succession certificate granted in his favor in case number 212 of 1996. It is also found from the exhibits that all the transactions showing sale and purchase of the shares and securities took place during the lifetime of Swarup Bikash Sheth, with the monetary profits earned by him from the estate of late Sushil Kumar Sheth. It is clearly found that from the materials on record that the shares and securities were purchased by Swarup Bikash Sheth out of the income of the estate of Sushil Kumar Sheth. My lord, kindly considers, my lord, the scope of remand. Whether, my lord, at all, my lord, these issues can be, my lord, further gone into after, my lord, the remand order was made. It is clearly found that the materials on record that the shares and securities were purchased by Swarup Bikash Sheth out of the income of the estate of late Sushil Kumar Sheth. And as such, the plaintiffs are the heirs and legal representatives of the said Sushil Kumar Sheth and are entitled to get the undivided 56 share of those assets left by Swarup Bikash Sheth. The two passbooks, Exhibit 29, and statements of account, Exhibit 26, 22, and such, and support the plaintiff's case. And it is true, and that the Swarup Bikash Sheth during his lifetime procured all those shares and securities in his personal name out of the income of the total income of the estate of late Sushil Kumar Sheth. Section 383B of the Indian Succession Act supports the plaintiff's case. It is found that from the Exhibit 16 that the defendants deliberately made false statement by concealing some material facts. Exhibit 16 supports the plaintiff's case. Exhibit 8 also supports the plaintiff's case. It is found that the application for grant of extension of succession certificate was filed by the defendants not according to the provision of law, and they do not hesitate to make such application for obtaining extended succession certificate by practicing fraud upon the learned court, and on that ground the extended succession certificate is liable to be cancelled or set aside. From the materials on record, it is clearly found that all the subsequent acquisition of such shares and securities was made with the nucleus of the property jointly possessed by the Hindu undivided joint family, consisting of the plaintiffs and said Swarup Bikash Sheth. Exhibits 1 to 32 supports the plaintiff's case very much, and I find no reason to disbelieve those. Exhibit A does not help the defense case at all. The ruling reported in the written argument referred to by the learned advocate of the plaintiff suppose the plaintiffs. On the other hand, the ruling referred to by the learned advocate for the defendants do not help the matter, and as the facts stated therein are different facts stated in the present case. Now the plaintiff have filed this suit for declaration, injunction, and plaintiffs of their own value. Considering skipping considering the facts and circumstances of the case and the basis of materials on record, I find that the plaintiffs have been able to prove their case that they are entitled to get a decree as prayed for in this case, and the learned advocate for the plaintiffs also prays for all the reliefs are sought in the plaint. Hence, it is ordered that the plaintiffs do get a decree of declaration and permanent injunction as prayed for against the defendants on contest, but without cause, as per prayer of the plaintiff. It is hereby declared that the plaintiffs are joint lawful owners to the extent of 5/6 share of the total share and securities left by said Sharup Bikas Shet, the predecessor in interest and title of the defendants, who are jointly entitled to have their share to the extent of remaining 1/6 share of such total share and securities left by Sharup Bikas Shet, and more fully and particularly described in the schedule given in the plaint in the said suit, as those shares and securities had been acquired by the said Sharup Bikas Shet in his capacity as Karta of the undivided Hindu joint family of Sushil Kumar Shet. And it is hereby, and it is further declared that defendant numbers 1 and 2 have got no manner of right to have those shares and securities as absolute owners thereof on the strength of the impugned extended succession certificate granted in Act 39 case number 234 of 1995 arising out of such and such, which is a product of fraud, misrepresentation, and or suppression of the material facts. And as such, the same is absolutely ineffective, inoperative, having no legal effect, and the same is not binding upon the plaintiffs, and the same is hereby revoked and or set aside, and the defendant number 1 and 2, their main agents, employees are permanently restrained from giving effect to and further to and from acting on the said extended succession certificate issued in the such and such case. Therefore, my lord, kindly considers, my lord, may I take your lordship again to the, my lord, the order of remand, where, my lord, the specific issue, my lord, was mentioned.
But there were several findings in the order of remand. Suppose at page 166, the appellate court held that we find from the record that sufficient evidence had not been adduced at the time of hearing as to the exact number of shares and securities held either in the name of Sushil or Sharup, and the learned trial judge did not come to a definite conclusion whether those shares were really transferred in the name of Sharup Bikas Shet or are still appearing in the name of Sushil. Even the actual amount of money realized by Sharup by virtue of succession certificate. So these points are also there. 5/6, we hold that plaintiffs are entitled to get 5/6 share of money already realized.
That portion, my lord, has already been decided. That
has
A and B.
Yes, yes.
The
5/6.
5/6 plaintiffs
But
are the
whether
owners
that
of
was
5/6.
realized by Sharup because from the estate.
My lord, the word is, my lord, at all.
Where? Page 167 starts with, in this proceeding as the original shares could not be produced, whether indicating whether those have been really changed in the name of Sharup Bikas Shet or not. We are of the view that the matter should be remanded. So the subject matter of A and B were only the shares of the companies.
Shares.
Only the shares.
Only the shares of the company. My lord, my lord, may I take your lordship to the schedule of the, my lord, extended succession certificate,
which is similar to the plaint schedule.
My lord, 8 number of shares are, my lord, in the plaint, which are, my lord, not in the, my lord, extended succession certificate.
So you say the limited scope was to.
Well, the limited scope
whether the shares still stand in the name of Sushil or have changed.
My lord, kindly, my lord, comes to page number 289 once, my lord.
29.
289. My lord, this starts at, my lord, page 283. It starts, my lord, my application. My application under section 376 on the Indian succession, my lord, for grant of extended succession certificate, my lord. 289, my lord, the schedule starts. Which, my lord, they dispute. The 289 you are not entitled.
What were the documents produced by them before the? So according to you, what was the, if a question is to be formulated, what was the scope of remand? What do you say?
My lord, kindly sees, my lord, the scope of remand, my lord, whether how much the quantum, the exact quantum of money, if at all anything has been realized, my lord, by Sharup, whether at all anything has been realized, how much, my lord, the plaintiffs are entitled to. Well, this was the limited scope.
That is what has been done. It has been said that those shares were purchased by Sharup in the name of.
And my lord, for that question to be answered, my lord, this honorable court, my lord, even my lord directed the parties, my lord, to adduce every, my lord, to summon the, my lord, the companies also,
if necessary, or something like
that was not, my lord, no effort was to
free
my lord,
to summon the concerned company. That is one of the modes.
My lord, to that effect, my lord, nothing was
But
put
the
into, my
money
lord.
trail was probably proved to show that the deposits were made. These shares were purchased from the
My lord,
coffers of
what
Sushil.
this honorable court, my lord, already, my lord, declared, my lord, to the share to the extent of 5/6 in
This
regard.
court only declared the shares 5/6 and said that you had failed to prove that breaking of the Almara and all, that you had given.
That case is gone. That case has
So
got
you have not
disbelieved.
returned their share.
No.
Nothing
No.
to prove that.
No. And my lord, whether how much was, my lord, realized by, if at all anything was realized, how much was realized, my lord, all these questions are needed to be, my lord, gone into, my lord. And for that, my lord, it was remanded. For this limited scope, it was remanded. But merely for declaring that the plaintiffs are the owners, my lord, this
No,
was
their
already
evidence is
settled.
taken into consideration that the money was siphoned from Sushil's estate to purchase these shares by Sharup.
My lord, the nature of order, my lord, of this honorable court, my lord, in my humble submission, my lord, already, my lord, specifically, my lord, my lord, declares that portion.
Declares the shares.
Declares the share to the extent of, my lord, this plaint, my lord, kindly, my lord, takes up the schedule of the plaint. Schedule of the plaint, my lord, and the schedule of this extended succession
So
certificate.
then what was the reason for the remand then?
But to the extent of quantum of money, my lord, because share only, my lord, declaration of share, my lord, that would be a futile exercise unless and until, my lord, it is quantified. My lord, kindly, my lord, takes up, my lord, once more, my lord, may take your.
No, but this court decided the share, 5/6 share of the plaintiffs in Sushil's property.
In Sushil's property, my lord.
So their share of 5/6 was declared, right?
My lord, kindly, my lord, takes up page 166 once.
Yes. We are unable to call out the exact issue on which it was remanded.
My lord, it started with that only, my lord.
It was not specifically formulated.
When my lord, I was, my lord, initially briefed, my lord. It took me a few days for me, my lord, to get into that aspect only, my lord. My lord, page 166, my lord, kindly comes.
166, yes.
Well, the second paragraph. Although the learned advocate for the parties argued considerably on the question whether original shares were held by Sushil were really transferred in the name of Sharup, we find from the record that sufficient evidence has not been adduced at the time of hearing so as to the exact number of shares and securities held either in the name of Sushil or Sharup.
But the shares were not produced. Shares were produced.
My lord, in the shares, my lord, shares were produced. So far, my lord, the kindly sees, kindly takes
Shares will show they are in the name of which person? That those were not produced originally.
Those were not produced originally.
Now those have been produced.
Those have been produced. Well, the difficulty is, my lord.
But they stand in the name of Sharup.
Sharup, in the name of Sharup.
So you say if it is in the, that was the only scope of consideration.
Scope of consideration was, my lord, already, my lord, this case was, my lord, preliminarily decided in against me, my lord, by this honorable court. My lord, so far as, my lord,
you are claiming through Sharup.
I'm claiming through Sharup. My lord,
so if the shares are in the name of Sharup, then you are the. I mean,
my lord, kindly considers A, B, C, D, E, my lord, those 5 schedules were, my lord, subject of the succession certificate. In, my lord, the first succession certificate.
CD only.
First one, my lord, A, B, C, D, and E.
AB was not there.
My lord.
AB was not there.
First succession certificate, my lord, those all
CD.
No, CD, my lord, subsequently I gave up my claim for A and B. CD was decided, my lord, in my favor. My lord, my claim was restricted.
Oh, the claim was initially A to E.
A2E. What happened was A2E initially there was
Maybe you gave up your claim.
AB I gave up my claim
After 20 or 15 some years.
after
they
20
still-
years I made an application for extended succession certificate. No, give up to the
Yes.
extent of full share.
Full share, yeah.
To the extent of full
Right,
share. A2E, A and B. After 20 years, I make an application for extended succession certificate.
Now you say that you have full share in that.
Full share in that.
To Sharup.
And
now it is established that those stand in the name of Sharup.
now, not now, my lord, only my lord, the schedule of C, D, and E, that is the schedule of the plaint. That in itself is the schedule of the plaint, my lord. AB, my lord, the schedule of A and B, that in itself is the schedule of the plaint.
Excepting eight shares.
Excepting 8 shares. So this learned, this honorable court, my lord, already has held that A and B, 5/6 the A and B are entitled to. The plaintiffs are entitled to A and B, 5/6 share.
Then why was it remanded?
My lord, my understanding would be, my lord, to decide on the quantum.
Because court,
my humble sons, nothing, my lord, was left to be decided. It was already decided.
yes, exactly.
It was already decided.
Above questions has been said, but what question? We don't find any question before that. It has been held repeatedly. Plaintiffs will be entitled to get 5/6 share at page 160.
Already my case is gone. That I say that my case was already gone at that stage.
Yes,
So
maybe you have only 1/6.
Only 1/6. So only thing left was decided to be quantified.
Now it has been held that you had no share.
No, now
the entire thing was from the estate
no,
of Sushil.
cannot be because they are claiming.
Now it has been held like that.
Apparently seems so, but
you say that is beyond the scope of the
That is
because
beyond the
5/6. If 5/6 their share was held to be 5/6, by necessary implication you had 1/6.
1/6.
That has now been reopened and it has been said that Sharup purchased the entire thing from Sushil. The trial court now, that is your contention, that is your allegation, that the trial court now reopens the issue.
My specific allegation against my lord would be that, my lord, whatever the subject matter of remand was, that was not gone into.
Yes, but what has been done now? Your share has been negated entirely.
Reiterated. My lord, the observation of this honorable court, my lord, has been reiterated at length.
That does not harm you. You are not affected adversely by that if it's reiterated only.
Kindly see, my lord, I'll just, my lord, 174 GG.
To get a decree of declaration, permanent injunction on contest.
It is hereby declared that the plaintiffs are jointly lawful owners to the extent of 5/6 share, having 1/6 individual share of the total shares and securities left by
That is already held by this.
It is an interest on the title of the defendants, who are jointly entitled to have their share to the extent of remaining 1/6.
That is what was
My
held.
1/6 is protected.
That was held by the appeal.
That was held by the.
So why the appeal then? Why did you prefer an appeal?
Because, my lord,
not affected by this.
nothing conclusive came out. Kindly, my lord, kindly consider, my lord, these shares are needed to be, my lord.
That was never said. Not a single
My lord,
line devoted by the remand appellate court to say
as on today, my lord, as on today, my lord, I'll just, my lord, take your lordship to the
5616, the entire quantum, whatever is the quantum of the shares, 56 and 16, it will be divided like that. Because no partition has been sought. No, cannot be any partition of shares, but no distribution of money. Does the plaintiff ask for distribution of money also? They do not. So they wanted 5/6 share. It was held by the appellate court already that they have 5/6 share. That was reiterated. I mean, with utmost respect, we can't find any reason for remand also. Mr. Banerjee must be explaining that.
Yes, my lord, I would.
He was the architect of that.
No, my lord, initially, my lord.
Mr. Dasgupta was the architect of that. We cannot get hold of it.
My lord, Mr. Bidyut Kumar Banerjee, my lord.
Mr. Bidyut Kumar Banerjee lost. Mr. Dasgupta had that order.
Mr. Banerjee, my lord, means.
That was Mr. Bidyut Kumar Banerjee and Mr. Dasgupta is Mr. Sudhir Dasgupta. We cannot find either of them now. We can find the judge though. Anyway, we don't even understand why you are preferring the appeal. Why you have preferred this appeal pending from 2008.
Simply, my lord, kindly consider the
stalemate. The decree, abide by the decree. They have 5/6, you have 1/6. You have not challenged.
Consider, my lord, the stalemate situation. The situation is, well, a stalemate.
But the appellate court, while remanding, never uttered a single line saying that there should be a quantification. Not a single line. What was at best what we can find is, come to page 167, please.
Yes.
Read If you can please read from the second paragraph.
Parties are free to summon, my lord.
From there, please read on.
Yes,
This is
parties are free to summon the concerned companies where those shares are lying for the purpose of showing the strength of the disputed shares as it stands today. If it appears to the court that on basis of such evidence that the original shares of Sushil are still continuing in his name and those were not transferred in the name of Sharup Bikash pursuant to the succession certificate granted in his favor, the court will declare 5/6 share of the plaintiff and 1/6 share of the defendant in those shares.
Which is not the case.
Which is not the
because now it has been transferred in name of Sharup.
Some of the shares have been transferred.
And read the next paragraph.
If
The
it
other
appears
option, yes.
if it appears that any new share was purchased in the name of Sharup Bikash Sheth and the same is not in continuation of the original one standing in the name of Sushil, nor is such a share a bonus or right issue arising out of the share standing in the name of Sushil, nor was such share even purchased at a premium on the basis of benefit conferred on the share standing in the name of Sushil, the plaintiff will not have right
This is apparently the
in those shares.
However, then
the plaintiffs will be entitled to get 5/6 share of the amount of money already realized by Sharup Bikash Sheth by virtue of succession certificate, so long such amount is not paid to the plaintiffs. The said amount will remain charged over the assets of Sharup. The learned trial judge will further grant interest in the favor of the plaintiffs over. Well, nothing of this sort has also come out. But that is not, my lord, my concern. Nothing of this sort has also, my lord, come out.
But that was already decided by the appeal court.
Decided by the appeal court, my lord, but further evidence was, my lord, supposed to be laid on this. Whether, my lord, money was at all realized. If at all realized, my lord, what was the quantification of that money?
Yes.
That,
right.
but that
Right,
doesn't
right.
concern me. That specifically doesn't.
5616 has been declared.
Declared, my lord,
And it
previously.
only remains whatever amount you have realized. Like Sharup, your predecessor realized. And that has to be. So that has not been done in the trial.
Apparently not, my lord. Kindly see, my lord,
So those shares are still lying in their name. They have
even, my lord,
your predecessor's name.
My predecessor's name.
So have you realized those amounts?
No, nothing. My lord, that's why, my lord, I specifically, my lord, says it's a stalemate situation.
Let him complete, then we'll come to you, Mr. Banerjee. Yes, Mr. Banerjee, anything else to add? What
As
are
such,
but the documents? What are those? They show that Sharup purchased these shares from the estate, the joint nucleus.
Sharup purchased the shares from the joint nucleus. That is their case.
But if that be so, then also 5616 remains.
Also 5/6 shares, and my lord, it
It
cannot traverse beyond the schedule of the plaint.
No, does not add value to the plaint.
No,
because after this exercise of 32 pages, the trial court has come to the conclusion ultimately that it was purchased from the joint nucleus. If that be so, then also you have 1/6, they have 5/6.
And well, that is already held by this honorable
the appeal court.
By this honorable court.
Only what was to ascertain only was those shares were to be called for and to ascertain whether Sharup realized any
amount of money.
That means encashed those.
Encashed, and my lord, whether
or transferred.
My lord, it was already held that I did not pay anything, and whether, my lord, any money, my lord, I was, and any interest
It was to be seen. The shares were to be looked into, and it was to be found out whether those have been encashed by Sharup or transferred.
Transferred. That's it.
That is precisely what has not been done.
Not been done. Exactly, my lord. The scope of remand was, my lord, limited, which has not been done, my lord. Rather, my lord, whatever the this honorable court, my lord, decided already, that was reiterated.
Yes, apparently so. Apparently so. All right. So let us hear Mr. Banerjee. Yes, Mr. Banerjee. Your 5/6, their 1/6 has been decided by the appellate court itself. They cannot reopen that, neither can. Why should you? Because you have already.
That's right.
Now, what remains is.
His first bone of contention, my lord, is that at the time of passing a remand, this honorable court, my lord, in the first appeal, has already held 1/6 and 5/6. Then why there will be a further declaration in respect of 1/6 and 5/6?
Not only that, the appeal court also said, he says, apparently rightly, that those shares have to be the shares have to be produced if necessary by summoning the companies, and from those shares it has to be ascertained whether Swarup Bikash either encashed or transferred those, realize the amount from those shares. If he has realized, then the money was to be distributed, otherwise.
That's right.
But that has precisely not been done by the trial court.
No, that
It's
has
a
been done.
repetition of the. You should also have challenged.
No, not repetition, my lord. That has been done because remaining exhibited documents are not the exhibited document at the time when remand was made.
Exhibited documents, on the basis of the exhibited documents, Mr. Banerjee, ultimately the trial court reiterated that you have 5/6 and they have 1/6.
That is first part.
Acha.
There are two parts, my lord.
Acha.
One is first part, and second part, my lord, evidence was given, documents were marked exhibit, showing that the purchase of the company share, lord, that was in the name of Sushil. That was in the name of Sushil.
That money was transferred by Swarup, and with those it.
By Swarup, and Swarup repurchased it in his name, the same asset. That is a.
But that was not the scope of remand. The appellate court already held you have 5/6, meaning thereby the implicit in that was, it was implied that you have 5/6 means Swarup obviously took from the joint family nucleus and purchased those shares.
Because he argued, my lord, that some shares before the appellate court, some shares are standing in the name of Swarup.
That was turned down by the appellate court. Appellate court held you have 5/6 in all the shares. AB.
Yes,
Appellate court categorically held.
AB, my lord, in the name of Sushil at that time. Now, my lord, his case was in my name, that is in the name of Swarup.
Mr. Banerjee,
That is why
that was clinched by the appellate court itself, because appellate court held these AB shares standing in the name of Sushil. Now you have shown that it now stands in the name of Swarup. That was not the question. Appellate court held that Swarup, you have 5/6 share means that Swarup, it was implied in that Swarup had used the joint family nucleus and purchased those shares. So even if those stand in the name of Swarup, either Swarup or Sushil, it was held by the appellate court that you have 5/6, which has been reiterated. What was done, what the purpose for which it was remanded was, those shares were to be ascertained, to be produced by summoning the companies, and it was to be seen whether Swarup in the meantime further encashed those shares, realize the money from those, because shares are the subject matter of A and B, right? Shares, your share in the shares, 5/6/16 was declared in the subject matter of the property. No further declaration was necessary. Appellate court said, no, whether those shares which stand in your name already, 5/6, those shares were further encashed by Swarup. Those were, the language used was whether that those were realized. So that has not been, no evidence has been adduced on that. He further sold those shares.
They are the exhibited documents, my lord.
Achha, Swarup further sold those shares also.
Yes, collected those shares from the company and purchased in his name.
Achha, these purchases are further purchases.
After the but those shares, my lord, in the name of Swarup. But it is a blood from Sushil.
The joint nucleus. So these shares which are right.
Because the contention was whether shares is a joint nucleus, absolute joint nucleus, or shares are absolute shares of Sushil. So this is the only question for which, my lord, it was remanded. And that was, my lord, he did not issue any, he did not give any evidence, my lord, examination in chief after remand. I gave, Lord, evidence in this regard.
You gave evidence to show those shares were again transferred in the name of Swarup.
Fact finding was also given. Lord, I am placing before your lordship that finding of fact. In conformity with the new exhibited documents after remand.
So it boils down to what? This is a declaration on the new shares then also. The new shares are also held to be, but those new shares are not the subject matter of the suit.
Need not be, because my lord, that comes to the same blood
Stock from the same.
Yeah, from the same ratio. Therefore, no phrase declaration is needed, no phrase amendment is needed.
But this declaration has now been given in respect of the fresh shares.
Declaration restricted to the ballot. The plaint, our plaint payer.
I have not got. The plaint names the previous shares.
Yes. Now, Lord, it becomes a when a new shares, Lord, that is there in the name of Swarup, Lord, that becomes the share of Sushil. Therefore, it makes no difference.
That is what not what has been held. Please come to page 174 GG.
That's it.
Internal page 33 of the trial code. Trial code confines itself to the original shares.
Yes.
Just see, it is hereby declared that plaintiffs are jointly lawful owners of to the extent 5/6 share of the total shares and securities left by the said Swarup Vikas said predecessor and title of the defendants who are jointly entitled to have their share to the extent of remaining 1/6 of such total shares and securities left by Swarup Vikas deceased,
Lord,
as more fully and particularly described in the schedule given in the plaint.
Yes.
So schedule remains the original shares. You say there have been subsequent siphoning off by Swarup.
Siphoning that money.
But then those have to be incorporated in the schedule.
My respectful submission is siphoning that money. Lord, is
But the trial court is reiterating the appeal court's finding. Appeal court found that in the scheduled shares, you have 5/6, they have 1/6.
Yes.
And ultimately, after holding all this, the trial court again holds that you have 5/6 and they have 1/6 in what? In the scheduled shares.
No,
Given in the schedule of the plaint.
Come to page 174, AEE.
Internal page?
Internal page, my lord, 31.
31 is not the ordering portion. We are only on the ordering portion. Ordering portion, we are internal page 33. That is the culmination of the decree.
Yes.
It finds that you have 5/6 and they have 1/6 in what? In the shares more fully and particularly described in the schedule of the plaint.
Plaintiffs are jointly owners 5/6 share, 1/6 share of the total shares and security left by Swarup Vikas Seth, the predecessor in interest and title of the dependents.
So this has already been held by the appeal court.
To have the share to the extent of remaining 1/6 share of such total shares and securities left by the said Swarup Vikas Seth, as more fully and particularly described in schedule given in the plaintiff in suit, as those shares and securities has been acquired by the said Swarup Vikas Seth in his capacity as Karta of the undivided joint family since deceased, and it is further declared defendant 1 and 2 have no manner of right to have those shares and securities as absolute owners thereof on the strength of the impugned extended succession certificate granted. So far that part is concerned. Second part. Now, my lord, therefore, my lord, practically, my lord, the contents that was, my lord, mentioned in the schedule of the plaint, Lord, does not alter the character of the further purchasing these shares in the name of Swarup. When we have proved that it belonged to Sushil, which is out of A and B.
Appeal court already held that you have 5/6 share of
Yes,
money
appeal court already
realized by Swarup Vikas Seth by virtue of the succession certificate. Succession certificate pertain to A and B. A and B enumerate certain shares, and it was held that 5/6 share of money realized by Swarup Kumar Seth by virtue of the extended succession certificate. You have 5/6 share there.
Yes, that is why.
So those are the shares. That declaration has been given.
Practically, that is there. Exactly, that is. Now, Lord, the conclusion, Lord, the conclusion, if the Lord reasonings of the trial court is wrong, supposing, Lord, it need not be given by the trial court because it has already been passed by the appeal. Therefore, my Lord, conclusion is right.
Now, according to you, Mr. Banerjee, what was to be done by the trial court on remand?
Trial court on remand, my lord, it is to be.
What was to be done? What was the significance of the remand order?
Of the remand is that if any shares have been exclusively belonging to the defendant or not out of A and B schedule property. Lord, this is the only question. Out of A and B schedule property, my lord, whether exclusive property not belonging to Lord Susi.
But then the appellate court holds that you have 5/6 share in each in that.
Because they could not produce any evidence.
Therefore, it has been held. So another opportunity was given to them to show that they have exclusive title.
Evidence.
So they failed. Therefore,
Therefore, there is no scope for the purpose of he cannot be said to be an agreed person to prefer an appeal. Now, my lord, second, my lord, in the jar, my lord, 1, 2 plus 2 is equal to 4 is there. Now, my lord, when new purchase share was made, that is source is Susil, lord, 2 plus 2 is equal to 4 remains the same. Am I clear to your lordship?
no, 2 plus 2 generally is 4, but
Yes, same.
suppose if we follow binary mathematics, then it is not 4. So it depends on the axioms which you take.
Basically, it has come out of that. I purchased from Susil share. Same.
We are trying to understand, we're trying to understand why, what was achieved by the parties after this 17 years of pendency of this appeal.
Yeah.
We're trying to understand that.
He is the elder son. But at that time, Lord, I am minor at 15 years of age.
So, but you are not aggrieved in any manner. Mr. Banerjee is right on that. The other Mr. Banerjee, because you cannot be aggrieved. If you would be really aggrieved, then Mr. Roy would be arguing. You cannot be aggrieved by this. In any event, the appeal court order decree has been reiterated here.
The exercise is futile, my lord, according to me, my lord.
So it will be a futile exercise. This appeal is also futile then.
No,
What will you achieve by this appeal? If there was a futile exercise, let it be futile.
Well, the
Leave it at that.
situation, my lord, as of today, my lord, the still.
How has the situation changed after the trial court? Nothing. 5/6 shared, you have 1/6.
But as of
You had an opportunity to show you had entire share exclusive.
Yes.
But that was already, my lord, that was already settled.
So what is the use of the why are you aggrieved with the impugned
That,
judgment?
my lord, that portion, my lord, so far as my lord, my exclusive share, my lord, so far as my lord, the entire A and B schedule, my lord, that portion was already settled. And my lord, as of today, when my lord, no amendment of plaint has been
So
made.
we
my
cannot set aside this appeal, set aside this decree also. If it has only,
lord, on
we can at best hold that this decree is, does not say anything new. It has acted beyond the remand, but still the decree is correct. 5616 remains. It has not gone beyond that declaration.
no, only reiterated it. And my lord, so far as my lord,
We cannot set it aside because that will be set aside the remand order.
yes, whatever is my lord stated in the remand order, whatever share has been my lord declared in the remand
Something else was to be done according to you. So sufficient evidence was not adduced. Something else could not be done. That is not going beyond the remand order.
Let us reassemble, my lord, Monday.
Reassemble for 10 minutes only for this matter
Yes, yes,
on the next occasion. Yeah, heard in part for further hearing on January 27, 2025. Yes, Mr. Rai?
Well, that is why, my lord, I told at the very beginning.
Yes.
That big paper book.
No, you said.
But
Yes, right.
It
It will take 5 minutes, you said. We remember.
Your lordship,
And prayer I can make before your lordship, and next week, my lord, I'll be so difficult
We
for
will.
the we are going to
Mr. Kormokar also.
Kumbh.
You are kindly accommodate.
No. We are a secular country, no ground. Not sufficient. Kumbh, you follow your religion, but follow your practice also.
Yes, we just
Kumbh is from when to when? I am entirely out of the
26th, my lord. 25th February. We'll go there by 27th. We'll start from here.
And
29th is the date for.
So what period are you? All of you are going. Whoever is standing here, you are also going.
Saturday first, and then holiday. First,
Yes.
second, third, fourth is a holiday.
So you also do that.
Saraswati Puja, my lord, in the house.
No, so what are you wanting?
29.
27th to 29th, ask the Chief Justice to close the court.
Yeah.
Many of the judges are also going.
My lord, we have
Let the court be closed. Yes, Mahakumbh is happening. Why should the court function?
Total cleansing, my lord.
Cleansing.
we are already
After
clean.
cleansing, we feel for the river, rather the Sangam.
Joseph, we believe also.
But so, what is your exact prayer? I mean, if time is short for,
Only for that week. my
we
lord.
won't remember when it happens. Every time your juniors have to say,
Yes,
you have gone to Mahakumbh, and then we'll.
Yes.
Mahakumbh is the password. If you say Mahakumbh, we'll grant adjournment. So, you are also going to Mahakumbh? No, him.
He's
Then what? Oh,
Kormokari-
oh, he will suffer.
The juniors are standing
Acha.
but other than this, will not.
So we cannot assure you that we will grant time. We'll consider. There cannot be a general blanket order of.
Just complex and check.
So we cannot assure. How can we assure you?
No.
In advance, there cannot be any assurance.
The next matter, my lord, Monday week.
No, every matter will remain in the list.